Yes.
For this thing, my lord, regular first appeal, my lord.
I am not sitting. Regular first appeal is not before me.
May I please, your lordship. Item number 48, lordship. I have a prayer, lordship. This matter may be taken up at 2 p.m., lordship.
Why?
Lordship, I have a IA in this matter, lordship. Several times it has been listed, but due to paucity of time, it could not be taken up, lordship. I have a IA, lordship. That may be taken up. What if the result are?
Okay, what is this matter about?
Lordship, this is the RSA is regarding specific performance of contract, lordship. I am the respondent in RSA, and in the meantime, appellant party has started construction in the suit land, lordship. That is why I have a prayer, lordship.
You want to do it or not?
Yes, I want to do it
Okay.
at 2 p.m.
Don't
lordship.
make a mention.
Also some prayer. I was earlier counsel in this case. My name should be striker from this case. A. Paul.
Yes.
A. Paul and L. Wajida.
Ah.
Because some different counsel appearing in this case.
R. Sharma has already been engaged by new counsel, lordship.
Name of Apple and L. Wajida.
So that day matter came up, no? It's okay. We'll take it up.
My
Don't
name
worry.
should be striker, madam.
Have you filed any application before the registry that you are not there anymore?
No, madam.
Then don't make this type
Matter
of.
is listed. I have.
Don't make anything out here unless you say it before the registry. File it an application that your name may be struck off.
Okay.
Next,
Inform them that at 2 p.m. they will be available, lordship. The new counsel,
we'll see when the matter is taken up. Let's see, it's item number 48.
lordship.
We'll take it up, don't worry.
Deeply obliged.
In item number 33, I am going to file one amended application, amendment petition. So that will be taken up next week, lordship.
48 after vacation.
Right.
38, na?
33.
33. 33. After vacations, at the request of Mr. R. Sharma, appearing on behalf of.
I'm in this case, Lordship. This is a substitution application. The date may be fixed because it is a 2014 RSA matter, second appeal. Only the appellant has died. Has been abated also.
Debated?
Yes.
I file application for setting aside.
Then why are you asking for adjournment?
Actually, there is some mistake on my part in the delay consideration petition. I have written a
How much is the delay?
page lordship
1 year. 1 year.
Okay, don't worry. We'll take it up. We'll dismiss the matter.
Only thing, lordship, I have wrongly written the appellant left behind two sons.
You are
and a daughter.
eating somebody else's time. This is not your slot. We'll take it up when the matter reaches.
Listing of the case, RSA pilot 18 meters after vacation, my lord, because it was
Mention it after vacation. Yes, next.
possible this week.
No, nothing to.
Like to mention a RSA.
For what? Hearing. Why?
Was
Huh?
20. It was last listed.
So what?
One of the respondent had died. So
Very well. File if you have you are the appellant. File an application for a substitution.
On.
Yes. What is this matter?
This matter was heard earlier, my lord. Entirely. Only thing is that the respondent
Appellant, it has
had
been
come back.
informed that in appearing on behalf of the respondent, number 2 year expired, and it is also given only one which. Now, what did you do?
We have sent a letter, registered post, indicating the development. The names have been indicated on another day. We have tracked the application. We have received it, but they've not called back. Unfortunately, my lord, I must say that we still come back to the position where the degree can be executed. If cannot be executed, then I will not make a submission.
Huh?
If the degree cannot be executed in absence of the legal heirs, 1 or 2, there's then no point in adjudicating the entire fraction merits method. That's how I see it. Subject to what my learner change of everybody saying. Everybody got it.
Who died?
Respondent number 2, Umud Methi.
Two, Kumud Mehdi. The last time when the matter came up, means without substituting, you cannot go through this.
Because at the end of the matter, even if a decree is, it's upheld, then also executing court, there might be an difficulty. There might be an objection on the 47 also, on this count.
They won't. They can very well execute against the legal representatives. 146 will come in.
As what had fell through earlier, that the last occasion.
I only gave you a chance by getting that name. You had a good case,
I understand.
but I can't help you now.
Fully understand. Therefore, I'm not submitting any further. Unless everyone- I would pray that the communication which we have sent along with the postal receipt and track record be a part of the record. For the days to come, should be there. That we endeavor.
They have not replied. Pursuant to the order dated 35/2024, Mr. S. Bonig, the learned counsel appearing on behalf of the appellants, submits that he duly informed whom?
Follow Kaushik Rai Methi.
Who is he?
He comes in as a legal heir of.
Huh?
Also legal heir, not side.
Why haven't you informed anybody else? Kulu Bala Medhi or Monodip Rai Medhi, Rahul Medhi? Why? Who is Kaushik Rai Medhi?
Kaushik Rai Methi is the son of late Kamal Rai Methi.
Understood. Why
He is
you
a-
have
he-
only
he's one of the
informed
appellants.
one?
He's one of the appellant now, by substitution.
Recorded anyway. Oh, okay. 3-2.
Yes, 3-2.
He has informed the appellant number 3 Roman 2 that the respondent number 2 who expired on 24/10/2017 is survived by Srimati Purnima Medhi and Sri Raj Medhi. Full stop. The learned counsel also drew the attention of this court to the notice which was sent on 5/6/2024 along with the postal receipt and the track consignment, which also showed that on 11/6/2024 it was duly delivered to the addressee. For the ends of the said documents are kept on record collectively and marked with the letter X. For the ends of justice, this court fixes this matter again on September 3rd, 2024.
My lord,
Out of September.
a bit earlier, my lord,
Why?
because I will go out on 3rd of.
He will 3rd of September because I can't give it before. I'm putting three months, which is the abatement period otherwise. That is because 35 she came to know. The code, the 30th of August is a Friday, Saturday, Sunday, Monday is 2nd of September, 3rd is We'll have it on third.
Alright.
Otherwise, the next date it will, if it comes, it will come up for substitution. Otherwise, you have, it will go. And if it substitutes is done, then you don't have a case.
Alright.
My lord,
Yes, Mr. Das.
yes, my lord. The
What-
petition arising.
What have you challenged there?
Yes, my lord. We have challenged the Income order passed by the learned Motor Accident Claims Tribunal, Guwahati matter.
Annexure 4, page 40.
Yes, my lord. By the order, the limitation petition filed by the present petitioner was rejected on the ground that there is no sufficient ground to allow the petition
Yeah.
filed by the petitioner.
So, why should we entertain your petition here?
What happened, my lord?
You file a appeal against that order, MSC appeal. You filed an application for condoning for the purpose of review.
Yes.
So review condonation has not been done. Therefore, there is no review. You file an appeal.
Actually, what happened, my lord? Actually, review does not lie because it requires to be filed under order 1913. Expiry order was passed.
You file an appeal, you can't help it. It's the PP does, the learned counsel appearing on behalf of the petitioner submits that taking into account that the order which have been impugned in this instant proceedings is an order by which the application for condonation or delay in filing the review application was dismissed. He would not like to further press the instant proceedings. Rather, the petitioner would be well advised to prefer an appeal against the said order, against the said judgment and on order dated 7/8/2018. Taking into account the above, the instant petition stands closed on withdrawal. Full stop. It is made clear that the withdrawal of the instant petition shall not preclude the rights of the petitioner to avail such remedies otherwise available under law.
Kothi,
Yes,
My lord, this honorable court by an order dated 11/9/2023,
which order? Page
impugn order is page 84, my.
80. What is this order? As filed, the defendant has filed the petition number M1 has been filed under 10 and 11 of the CPC. What is 10 and 11? 10 is for res sub judice and 11 is res judicata. And what is this? What do you want? You want to stay?
No, my lord, what happens, my lord, get to the place before the law, a little background of the matter, my lord. Kindly see, my lord, page, annexure 1, page 27. It was a suit, my lord, which was filed by the predecessors of the respondent and myself, ourselves, as appellant, as plaintiff 4, 5, and 6. And
Now this SAO 5 of 2016 is pending.
Hello?
SAO 5 of 2016 is pending.
how is 2016 pending, man?
Is it? Sure. Because all SAOs I'm taking it up.
Yes, how was filed by them without impleting as party with them?
What am I way is SAO 5 of 2016 pending? You sure?
I have been impleted as a respondent here in this case because I was deprived in filing the appeal.
But normally there's no SAOs pending. Except very recently, because all SAOs are finished.
I am very much a party here, my lord, some respondent number 23 and 24.
Taksun, why SAO? We do one thing, get this matter listed with SAO on Wednesday. You finish it off. Your only problem is because of SAO, there is a stay.
I am a party implicated in the SO, my lord. I didn't-
No, Mr. Rajbal Bhuiyan, the only thing is because of the SAO, the proceedings have been stayed.
Proceeding is stage note of this, I am not against this, my lord. Let
Then
me-
why, you are against
My
what?
question is, my lord, together along with the respondent, we filed a suit, we got a degree. That degree was set aside with the order of remand. Then again, the remand order, they filed the essay without implementing us with them, without taking us behind our back. Subsequently, in 2003, having come to know, I filed an application and got myself included. Thereafter, what in the same subject matter, in the same suit led, they filed another suit against the state respondent without the plaintiffs themselves whom we are also plaintiffs. But this time, while filing the second suit, they themselves only filed the suit without taking us with them and got a degree against the government. And now they are announcing the suit length we have got, you are no longer in the suit. But initially, we are also.
Where is that order?
Yes, this is my, your last.
Which order? So you are challenging which order?
By filing our suit, we filed that order, my lord.
No,
And
no,
it's
which
my
order you are
page
challenging?
annexure, Page 39, my lord.
You are only
annexure two.
challenging the order of 31/5/2023. 31/5/2023 is the order here, page 84. What is wrong with this order? I peruse the suit records and the plaint of the instance. The plaint of the instance suit is based on the judgment and decree stated in here and still subsisting and binding upon the plaintiff and plaintiff claim relief in the instance for declaration that the so and so, so and so, so and so. The schedule of the remand is so and so. Admittedly, previously suit is now pending before the High Court in SAO. In view of the above discussions and looking into the object of AR to avoid multiplicities, unnecessary trial, the player is allowed. So why are you against this? Are you against this order?
Again,
Why?
My lord, this, they, in the same subject matter, I have drawn your lordship attention. They filed another suit.
No, Mr. Rajman, we are not concerned about what decree has been passed in other cases. We are only concerned with 31/5/2023. 31/5/2023, it states title suit number 176/2000 had stayed which one? So it's suit number 290/2022.
Suit filed by us, my
That suit has been stayed. So you want that suit should proceed.
lord.
So therefore, I was giving you the thing that let this matter be listed on Wednesday along with SAO's 5. If I dispose of the SAO 5, this order becomes infructuous. Isn't that? Matter ends. That is what I was saying. A simple thing. Okay. Taking into account the impugned order dated 31/5/2023, whereby the title suit number 290/2022 have been stayed in view of the pendency of SAO number 5/2016, which is pending before this court. This court directs the registry to list SAO number 5/2016 along with the instant writ petition, instant proceedings on 26/6/2024. At the motion stage. Yes, madam, what are you challenging?
Second will be after vacation.
Okay, at the request of the learned counsel for the petitioner, matters going to adjourn to be listed after vacations. Yes, what are you challenging?
I'm challenging the order of the learned civil judge in some with regard to issue of additional evidence. And whereby this honorable court already adjudicated similar issue earlier in the month of April, my lord.
Where is the order? Which order?
My lord, On similar set of facts, earlier your lordship has adjudicated, there are 4 petitioners. Now there are separate petitioners. So separate petitions are filed before this court.
Tell me what you are challenging here?
I'm challenging the order of the learned civil judge.
Which order? Page 61? You know which
Yes,
is
yes,
the,
yes. Petition
huh?
order 65.
now tell
61
me
to
why
65.
you are challenging it?
Because with regard to prayer for adducing additional evidence of some documents were declined by the learned civil judge. And one review petition has been also dismissed, which is lordship will find at page 61 on annexus 7.
Ah.
And another one is the annexus 6. A copy of the Mr. case number 22922, passed in title appeal number 1119 in the Court of Civil Justice, Kamrup Amingo. Page 56 onward, the issue of challenge in this case. We have prayed for some addition of some documents as additional evidence, which was declined by the learned civil. judge.
Additional evidence before whom? Is this a appeal
Appellate court, appellate court,
you want to bring in
yes.
under order 41 rule 27?
Yes.
That was rejected? When? By which order?
Possible annexus 6 and 7 is there.
Huh?
Annexus 6, page 56.
Annexus 6 is not an order, it's an application. You are not prepared, Mr. Paul?
No, I am prepared, Panda.
And then argue then. You're challenging which order? Let us see.
Oh, 52. First rejection was on 18/8/22, page 52. my
You
lord.
are challenging
Annexer 4.
changing the impugn order dated 28/7/2023 passed in Mizek case number Iman. So you are challenging that order of review?
No,
Yes, that is the only order you are challenging, 28/7/2023.
I have placed on record, in my petition, I have already stated the issue of challenge elaborately, but the
Where is the original order?
page 52 lordship will find.
Page 52.
The passing of the said order, my lord, we have obtained an RTI letter from the Court of Learned Munsi. And on the basis of, we have preferred another petition before the same court, which was also rejected. That's why you have approached before your lordship.
But you are not challenging this order of 18.
Yes, I have challenged the entire order.
Where?
In this petition.
Where? Show me the prayer. That 18/8/2022 I have already interfered with. So nothing remains.
Yes.
Why are you challenging again?
No, I have not challenged it again. I have challenged separately, my lord. That was different petitioner. My learned opposite side will clarify this position. There are 4 petitioners before your lordship in this court against the similar nature of order passed by the same court. They are separate grievances with regard to some tenancy issues. And 4 petitioners agreed by the similar nature of orders passed by the learned civil judge Amingao approached before your lordship separately. So one matter has been adjudicated by your lordship on 9/4/22, which I have placed on record.
No, it is on the same date.
Different dates.
It's the same date. See that order, 18/8/2022.
That's right.
But that is in different case.
Yes, different date. That's the issue.
That is 171. This is 172.
Only persons are different. Petitioners' names are different. Issue.
But here, Mr., you have not challenged that order of 18/8.
I have challenged, my lord.
Where?
Without any challenge, how can I approach before your lordship?
No, no, kindly come. See, where is your challenge to 18/8 in your prayer?
But I have.
You have challenged the review order.
Yes.
Review order is immaterial.
Impugned is, I have impugned the last order, which was passed in the year in Mizia case 229/22.
Mr. Counsel, withdraw this petition, file a fresh one challenging 18(8). You see, once the review is dismissed, you have to challenge the main order. This is the basic element of Order 47. You can't challenge the review order, isn't it? See, language of Order 47.
Lordship may kindly come to paragraph 4 of this order of your passed by your lordship in this last order in the case of Sujya Kalita, my lord.
When the application for review is heard, an order of the court rejecting the application shall not be appealable, but an order of an application may be objected to at once by an appeal from the so and so. When an application has been rejected in consequence of the failure of the applicant to appear, so and so. Now, this is the law. You can't challenge this order. You have to challenge the 18(8) order. Withdraw this. File a 18(8).
Then, my lord, the outcome of the last order,
That's immaterial.
that is not necessary.
That is immaterial. So you can very well explain why you have come late. Because you filed the review, the review got
If
dismissed.
your lordship kindly consider the paragraph 4 of this order of your lordship, kindly, both the orders are, deliberately,
I've seen this.
in
I
fact,
know it, but unless you challenge this, how do I do it? At the end of the day, after 1 year, this matter will come up, and after 1 year, it will be. On the other hand, it will delay his proceedings. He is the landlord. So you need to withdraw this, file a fresh one challenging 18(8). Huh? Yes. You have to challenge 18(8). You see the judgment of the Supreme Court, I'll show you, I'll give you a judgment of the Supreme Court categorically mentions the 2012 6 SCC 782. 12 6 SCC 782,
then my lord, I have to incorporate.
where it says the second situation that one can conceive of is where a court or a tribunal may make an order in the review by which the review petition is allowed and the decree under so and so is reversed. Such an order shall have to be a composite. The third situation is with which we are concerned in the instant case is where the revision petition is filed before the tribunal, but the tribunal refuses to interfere with the decree or order earlier made. It is simply dismisses the review petition. The decree in such a case suffers neither by any reversal or any alteration or modification. It is an order by which the review petition is dismissed, thereby affirming the decree or order. In such a contingency, there is no question of any merger, and anyone aggrieved by the decree or order of the tribunal or order shall have to challenge within the time stipulated by law the original decree and not the order dismissing the review petition. Therefore, Mr. A. Paul, the learned counsel, appearing on behalf of the petitioner, submits that in view of the judgment of the Supreme Court in the case of DSR Steel Private (private is limited) versus State of Rajasthan, reported in 2012 6 SCC 782, he would not like to press the instant petition, taking into account that the petitioner herein ought to challenge the order dated 18/8/2022 passed in Mizze case number 172/2022, arising out of title appeal number 11/2019, full stop. Taking into account the above, the instant, he, however, submits that the withdrawal of the instant petition should not preclude the petitioner to approach this court if the petitioner is aggrieved against the order dated 18/8/2022 passed in Mizze case number 172/2022. taking into account the above, the instant petition stands closed on withdrawal. Liberty, however, would be there upon the petitioner to avail appropriate remedies within avail appropriate remedies if so permissible under law.
Problem. It is, madam.
Hmm.
Sir, this revision petition is in the form of a mercy petition, madam.
Mercy? Mercy is no mercy. I don't have mercy. Mercy, which one? 9/5/2024 order. What is that order?
It's closed.
Huh?
EWs were closed, madam.
EWs were closed. How many times?
Technically speaking, 4 dates I have taken. Otherwise, my lord, the PO was on maternity leave. So the EW,
Huh?
the PO was on maternity leave, madam.
Why you could not file it?
Madam, because of the illness of the present defendant number one.
Huh?
Illness of the defendant number one. He is about 90 years old, madam.
So is he the person who is going to swear the affidavit? The affidavit is ready
Affidavit, madam, I'll file it in the next day. It's ready, madam.
tomorrow?
You have to, I have to communicate also. I'll file it, madam.
You said it is ready.
Madam, gives me 3-4 days, and I'll file it.
Fixing for arguments 27/5. What happened on that day?
27/5, my lord, I took an adjournment. 27/5, my lord.
And what is the
20 took
next
an
day?
adjournment. 20 took- next day it comes 10th of July.
10th of July. It is in Guwahati?
Kokrajhar,
Raja.
Borbeta, madam. Borbeta.
What is the suit for?
Declaration of right title interest and recovery of possession.
You file your written statement?
My lord, I have- In fact, my lord, I had purchased the suit then way back in the year 1966.
That is not concerned. I am not concerned. I am only filing away. You are the only defendant.
There are other 5 defendants, my lord, but I
Happened
have.
with them. Who are those?
They are my brothers.
So they have not approached this court. So they don't want to file.
I am in the position of the man. They won't file, only I.
And where is your medical document?
Medical documents, my lord, 90 years old, my lord, for every ailment, my lord, I cannot give.
So how many years? How many times did you take adjournment?
Adjournment, my lord, technically I took 4 adjournments.
Show me your petitions.
Petition, my lord, at page number.
Both sides are
27.
represented. Evidence of DW is to be filed on the next date.
27 is my application. Page 20.
So it was first fixed on 33/2022.
24, 2022.
33
At page, my lord, 34.
for DW.
DW.
Then one date 24/2022. Second date
33, it was fixed, my lord.
Uh,
I had to file.
24/2022. Second date. Then for defendant file petition with a prayer for another date. Defendant side is absent. Then PO goes to maternity. Evidence is to be filed on the next date, 9/2/2024.
922.
For evidence, 9/2/2020. Both sides has filed a petition seeking time to file DW citing illness. None appeared to move the petition. Petition is not accompanied by verification. No medical documents furnished. This is a long pending case. So. Okay. And why did you move so late? You are challenging the order of plaintiff have argued their facts. Defendant has prayed for an adjournment by which allowed them to direct another that the next date without fail. Speak so and so for further arguments. 18/6.
18.6, nothing happened, my lord. Next date is fixed on.
Huh? No. 18.6. Kindly come to page 54.
My lord. 18.6, my lord. 18.6, it was fixed for argument, nothing happened on it.
For further argument. Then again you took time. Oh. Case is made up.
Just one chance, my lord. Next, I will file it, my lord.
Cost?
Cost, my lord, reasonable cost.
1 lakh?
Yes, my lord. My suit value is 2,000, man.
Huh?
Suit value is 2,000.
Yeah, you should not. What is the value of the land? 4 bighas.
But the suit is valued at 2,000.
So you must have challenged it.
But my lord, I have purchased it way back in the year 1956, my lord.
You purchased, this
They
is a
have not
different thing.
challenged my sale kit, my lord. Right away, they have filed this suit. Only one chance.
No.
Maybe fix in the next week, my lord, I'll file it. Or 2-3 days, my lord, I'll file it.
When did you file this petition?
Hello, revision petition, my lord.
Huh?
This was filed, my lord,
On 14/6.
14/6.
Did you inform the court
I have informed you.
that, yeah, but then also the court fixed it on 18/6.
Thereafter, that's why, my lord, 18/6, nothing happened. And it was fixed on 10/7.
Where is the order of 18/6?
18/6 also.
Why?
I was informed telephonically, my lord, that we have taken time.
Let us see the order. Take it up after some time.
But
What
it's
is
not
the order?
uploaded.
Huh?
It's not uploaded.
Very well. Get it out there. Take it up after some time. It is otherwise in 10/7, na?
10/7.
Let's have it on 26, get that order. List the matter on 26/6.
Keep progress.
For 7 permission.
Well, this is the matter in which the land of the petitioner is taken to the Guwahati.
Yes, you are taking any steps for acquisition?
In fact, the petitioners had been gone to the DC's office for a meeting.
Huh?
The meeting was convened by the DC and the petitioners were present there, wherein a proposal was laid for them that the acquisition process will be completed and there will be compensation. And they have agreed to it.
The publication has happened
Yes. Publication has
under
happened.
section 6.
Yes, everything. So everything has been regularized and they were called, my lord, all the petitioners and their representatives were called by the deputy commissioner, district commissioner. They had a meeting. They had no grievance with the quantum and the process taken up for, my lord, acquisition. So therefore, the matter will be sorted out. Lordship may be pleased and my lord,
In fact,
my learned colleague will place the
Director of Medical Education has already submitted a proposal to the government in the health department.
health department, since it is the requiring department, they have already set up the demand. Now, the petitioners will be entitled to an amount of 11 crores, 14 lakhs and odd amount. madam.
Already given that.
It-
No, proposal has been given, so Lordship will post it immediately after the vacation. I will pay the status, my lord. It's now, my lord, everything is going.
When are you passing the award?
My lord,
When are you passing the award?
That my lord, lordship will kindly be pleased to post it
They
immediately.
are only the persons.
Yes,
You have it on 1st of August, 1st of August,
prior to that also lordship will.
1st of August. On that day, produce the award statement, we'll close it. I think that is the better option. Unnecessary, means again fixing another date, no.
It has all happened because of your lordship's activism. We must fairly, my lord.
No. Pursuant to the order dated 25/2024 passed by this court, the Mr. Arbor Pujari, the learned standing counsel for the revenue department, had placed before this court an instruction issued by the district commissioner, Kamrup Metropolitan District, dated 19/6/2024, whereby steps have already been initiated under the Assam Land Record Requisition and Acquisition Act 1964 for acquisition of the land of the petitioners. The said case is LA case number 9/2024. Mr. E. Gogoi, appearing on behalf of the Health and Family Welfare Department of the Government of Assam, appearing on behalf of the Director of Medical Education. Is it under the Health and Family, na?
Yes.
Health and Family Welfare of the Government of Assam.
So, madam, it will be my lord, medical education and research department, because it relates to medical education,
Appearing on behalf of the Medical Education Department of the Government of Assam, submitted that already steps have been taken for the purpose of placing the demand of rupees 1114.30542 lakhs. And there is a likelihood that the same would be released very soon. Mr. Arbor Pujari further submits that as already steps have been taken by issuance of notification under Section 6(1) of the Assam Land Record Requisition and Acquisition Act 1964. The award will be passed immediately upon receipt of the amount from the Medical Education Department. Taking into account the above, this court directs the means in the petition be listed again on 6th of August,
6th of August.
on which date the counsels appearing on behalf of the Revenue Department as well as the Medical Education Department, including the petitioner, shall apprise this court as regards the status. The said documents which have been submitted by the learned counsel appearing on behalf of the petitioners, appearing on behalf of the respondent authorities are kept on record and marked with the letter M and N. Respectively.
So, maybe please to indicate something about the award.
I said,
Award. Yes.
likely to be passed on yet, therefore I'm
Yes, yes, we will
fixing it.
produce it.
Yes.
That will.
On the next date, the council appearing on behalf of the revenue department shall also take appropriate steps so that the award is placed before this court.
I'm so obliged.
Yes,
I'm challenging the order of the trial for your lordship.
within time,
No, your lordship.
delay,
Lordship, it is the appeal, your lordship.
is it within time?
within the-
Divorce. Granted,
dismissed because, your lordship, the petition was filed. The divorce petition was filed under section 24 of the Special Marriage Act, your lordship, but the grounds mentioned in the divorce petition was under section 25, your lordship. It ought to have been section 25, but the council of the court filed the section under 24, your lordship. The ground,
Should have.
the divorce was, your lordship, the grounds mentioned in the petition, your lordship, may I read?
Why don't we do one thing? These type of matters it shouldn't be so technical, no? You file your application under 24. It should have been under 25. So wrong quoting.
Trial court also had
Huh?
ought to have given a chance to the council, your lordship, to correct the petition, your lordship.
You wanted a nullity.
But the ground, the marriage was a voidable marriage, your lordship, because the marriage was taken under duress and
Chalo,
force, in your lordship.
you are a husband or wife.
I'm quite, your lordship.
20 years. When did you marry?
Your lordship, when she was in 18 years, your lordship, then the marriage was solemnized, your lordship. When the petitioner was, your lordship, 15, 16 years, your lordship, the respondent used to follow her to the college, your lordship, and he used to pressurize her to marry him, your lordship. But
Appeal admit call for the records, issue notice, steps by registered as well as the usual within 7 days.
your lordship.
May it please your lordship. My lord, this copy is not LA petition is heard. And my lord, the similar situated case, already series case, already Honorable Justice M.R. Pathak in open court dismissed the case.
Who?
Justice M.R. Pathak, Honorable
When?
Justice. But my lord, this order is not
But
made
the
on
judgment
line.
petition is allowed, the petitioners are
22,
entitled to an award for
12,
determination of
2023.
compensation, the value of the land of the assessed. Yes, why are you challenging it?
My lord, lordship, my lord, the grounds, my lord, lordship will see, my lord, that my lord, if your lordship, my lord, the order is at page 11, my lord.
Hmm.
Lordship, kindly come to page 11, my lord,
Hmm.
this judgment portion, my lord. Second paragraph, my lord, the area of land, my lord, is, my lord, 3 biga, 3 kotha and 10 lessons, my lord. And my lord, here are two registered sale deeds were, my lord, exhibited
Hmm.
by the, my lord, applicant, my lord, here at, my lord, before the district court, my lord, district judge, my lord.
Have you paid the money?
My lord, paid the money.
Entire as per this award.
No, as per this order, my lord, as per the order of the, my lord, collector, my lord, that was paid, my lord, they have taken it, my lord, without any objection, my lord.
They must have made it. Without protest, they can't file an application under
No,
18.
my lord, I have categorically said, my lord, that they are, my lord, I have limited information, my lord. What else, my lord?
You have no information. You are not the person who even certified the appeal. How do you have information? This is on certificate.
My lord.
Then
So, my lord, whatever.
I would have understood who the lawyer who had certified the appeal would have said that.
My lord, the thing is.
You
this,
don't
my
know
lord,
anything.
here It is written here, my lord, that, my lord, without any protest, they have accepted that money, my lord. It was taken by.
Then?
Hereafter, my lord, they have come for before the, my lord, the learned district judge, my lord, and my lord, the application was allowed, my lord.
Huh.
And my lord, against that, my lord, we have come.
When was it allowed?
My lord, it is.
2016.
Yes, my lord.
We are in 2024.
Yes, my
Why
lord.
should we admit the appeal?
My lord, we have already, my lord.
Pay the entire amount as per the decree, then we will admit. Yeah, quantum, it is a regular appeal. So you pay that amount. We apply order 43, 41, rule 1(3).
My lord, yes, my lord. You can, my lord, my
But
lord.
we now ask that the reappropriation should be done as per the new act.
No, my lord. No, my lord, because already, my lord, amount has been paid, so my lord, new act, my lord, cannot come, my lord, probably, my lord.
This is an old matter. The acquisition was done when?
my lord, in 2008-9, my lord.
9. Then
Thing is this, my lord, the exemplars of which were, my lord, the 2 certified copy of the, my lord, sealed it, my lord, which were, my lord, taken, my lord. My lord,
show me your written statement.
my lord, I have not an expert.
Then how can you file it? Not next. You have it. You have a copy. Then how do you say that it is under protest?
My lord, my lord, kindly see, my lord. Lordship may kindly see judgment, my lord. One portion, my lord, I would like to, my lord, point out, my lord.
Hmm.
Case 12, my lord.
Hmm.
The, my lord, para, my lord, 3, my lord. It is though it is not numbered, my lord, and my lord, third para, my lord, in case 12, my lord. The Indian Railway also has submitted a written statement stating inter alia that the state government had fixed an award excellent compensation at the rate of 38,000 per biga, along with 30% solicitum and 12% interest, and the petitioner also received the compensation without objection, my lord. That is the, my lord, finding of the court, my lord. It is submitted that the required land is situated at the far outskirt of the Dudhoi revenue town, far away from the land NH 37, and the land is agricultural land and having no approach road to it. That apart, there is no residential houses near the acquired land. Even the Dudhoi railway station is at far away. Therefore, the opposite party paid for dismissal of the petition, madam. Madam,
Yes. Did you accept it under protest?
Copy is not served the LA appeal, and my lord, some already.
I'm asking you a specific question. You were very fast in saying that there is a coordinate bench decision wherein it has been dismissed. But you say, when I put a question to you, say that you don't know. Did you accept it without objection?
Objection, my. Objection, my.
Huh?
Objection, my.
Where is the judgment of the coordinate bench? Show me.
madam, not been delivered, madam.
Huh?
Madam, there are 32 cases, madam. We have filed, madam. Some 26 cases are taken by another bench, madam, which was, madam, CAV, madam. But, madam, I do not know, madam, the outcome, madam. The judgment has not been given.
My lord, this open court judgment, my lord, similarly situated in Golgota district case, series, my lord. In open court judgment is, my lord, the LA case is dismissed, my lord. And my lord, this my lord, order is not made online, my lord. So time may be for
When was it dismissed?
dismissed, my lord, 22/12/2023 by this honorable Ahmad Patel.
Can't be online, has not been made. And if it is not, then it is a serious aspect. Okay, appeal admitted, call for the records. Mr. Swenso appears on behalf of all the respondents. Accepts notice extra copies of the memo of appeal be served upon him. Who is appearing for the government? Mr. No, none appears for the government. Government counsel. Hey, here, Mr. T.R. Gogoi was sitting, no? Mr. T.R. Gogoi accepts notice on behalf of the performer respondent number 2. Mr. A, he appears for respondent numbers 1 to 6. You are appearing for respondent number 7, nah? The performer respondent number 7 appears for the state of Assam. Full stop. Extra copies of the memo of appeal be served upon them within 3 days. Full stop. Call for the records. Full stop. There is no requirement of any further notice to be issued. Upon receipt of the records, matter will be listed for hearing.
Our names should be reflected in the court.
Whose
Yes.
history shall show the name of the council's representative. Did you file your Wakalatama?
Yes.
Your name is shown.
At number 10,
Yeah.
Concurrent findings against.
Huh?
Concurrent findings by the court.
Oh, you want to do it? And to take your risk, to take your risk, but don't start it, then don't later on just say that no, not now. Tell me, quick.
Another day.
The request of the learned council for the appellant matters constituent to be listed after the petitions.
Obliged.
Yes,
Yes, my concurrent finding.
you want to do it, same question. Once I take it up, then you don't go away. Tell me,
Here, my lord, learned trial court initially, my
Yeah.
lord, it was my lord past judgment, learned mistake, my lord, against me, my lord. The land, my lord, actually it was a government land, but in spite of that decree has been, my lord, passed, my lord. A decree declaring the her plaintiff possession of a Schedule C land out of Schedule B land
who are you?
for the, my lord, respondent, my lord, number, sole respondent is, respondent number one.
You are the appellant.
Sorry, I am, my lord, appellant here and
Whether
defendant
so and
number
so
one,
is correct. To
defendant number
decree
one.
the suit land of so and so to deliver so and so by evicting here have no right title and. 2A is not a substantial question of law.
Yes.
It's correct to decree
Subs-
the put land in favor where the particular plot of land is a government land. Similarly, claim of dispossession from Schedule C land of here is correct to deliver khas possession of him. Right is vested upon. Whether the vendor of the Iman has any such right to execute with the said respondent to deliver its possession when he has no title of so and so. Whether Kacha sale deed of the appellant executed by different plot of land has in validity and so. None of it as a substantial. Chalo, we dismiss it.
No, my lord,
No, you don't have it.
here, my lord, what is happened, my lord, right? That-
Nothing. It's simple case. Both of you are staying in government lands.
Yes,
You must have
yes,
dispossessed
I
him.
am in government.
He is also.
He is also.
So he would must have dispossessed him and he filed the suit for recovery. 64 comes in based on not on title. Article 64 will come in. A suit based on possession. He has to file it within 12 years. He files.
I am in possession. Admittedly here in the mansion.
Understood, but how can I take into account that?
Yeah.
Yes, that is why it's a suit for right for the recovery of possession.
My lord, it was, my lord, purchased from the defendant number two. He is brother of the respondent, my lord.
So
Admittedly, it is mentioned in the,
where is your plane?
yes, my lord, my plane, this airplane. Is a file, affidavit in opposition. Plane starts from space 69, my lord.
Page
69,
59 is not a plane.
69.
69. A suit for declaration the plaintiff has right title interest over the Schedule C land out of Schedule B land and for the of khas possession of immense lands. How can there be a registered deed of sale?
Yes, my lord, in their favor.
Huh?
First, in their favor, plaintiff favor.
How?
I do not know, my lord, that was there, mentioned here. And I have stated here, my lord, in the WS, in paragraph, page 73, paragraph 7, my lord. Photo holder, how can, my lord, they
Lordship sale deed was registered on 1981. At that time, registration maybe happened.
Huh?
At that time,
What is it?
is not produced, no?
no. I not photo. Exhibit one,
That,
exhibit one,
photo tamil kora hai.
exhibit one, exhibit all registered. अपनों लोगों को
আমার তো নাই আছে এ মাটির পাত্তা তো নাই করা
You are a plaintiff?
I'm the plaintiff.
Now there is two deeds of sale. What is this deed of sale? The number 2010? Yes.
This Casa did this belongs to, that was not here, in the lower court below.
Okay, but she has purchased it from the Khatian holder.
Yes,
And thereafter she was in possession from 1981 and then you took over the possession
yes,
sometime.
my lord. In 2010, that was the brother of the my lord, plaintiff, my lord, purchased that loan. Subsequently, amount returned also. That amount has been returned, but he is in possession from the year 2026-7, 2010 onwards, my lord. That is only case. My claim is that is the government land as I am in possession. She is staying here in Guwahati, my lord. And that land was vacant land. At that time, brother, my lord, also, it was the land of the one Dehiram Das, my lord, father of the plaintiff, my lord. No, my lord, vendor of the plaintiff, my lord. Subsequently, two brothers were there. One brother sold, my lord, to the plaintiff. Another brother, I
Okay,
can
but
say,
you don't have a case.
that is the only ground.
Lordship, they claim.
Okay,
that
okay, we dismiss the appeal.
No, let me after vacation. then.
No, I asked you before that. I started it. I gave you an opportunity like
Then
Mr.
just I
Datta.
want to place one
Mr. No, you don't get it.
paragraph 7, paragraph 7.
They
I
even
want to
did
read.
not exhibit the Kacha cell date. Lord.
Casa cell
Kindly
did not,
see
but he is in
Paragraph-
possession.
Page number 57.
And go, just I want to place my lord, only paragraph 7, my lord,
Seven?
of my WS. Of WS, paragraph 7.
That is the government land.
No, my lord, just I want to, yes, my lord, paragraph, page 73. Page 73, I want to place this paragraph.
Yes.
That this statement made by the paragraph to plaint such as a scheduled land stood in the name of Sri Umesh Das, son of so and so, measuring 3 bigha scheduled land of the plaint to the plaintiff by registered sale date 81. Even delivery of possession to the plaintiff has been possessing the said land. The name of the plaintiff had been mutated over the said land in place of.
This is, you see, this would not help you. You could not prove anything.
No, just I want to place my lord, it is mentioned, specifically mentioned. Sri Umesh Das got no right title.
Enough. Mr. Das.
Hence, the plaintiff not acquire any right title, my lord. By the sale deed number
Okay,
81.
no.
The plaintiff also never possessed the said B scheduled land
Okay.
at any point of time. The defendant is in rightful possessor, my lord.
Mr. Das, this lifetime I don't have the opportunity to look into. Now, dismissal.
I am in possession, my lord. I have
So what?
only residence.
That is what I suit for, to remove you from possession.
But,
Isn't
here-
that isn't that suit for the recovery?
but it is, according to me, my lord, it is-
In the suit for recovery,
Yes.
there is the
Yes,
are
recovery and
illegal
permanent
trespassers on Niman and by evicting the defendants from Schedule C land and removing all structures by the defendant in the Schedule C land and deliver khas possession in favor of the plaintiff and also declare the Kacha sale deed as void, null and void, inoperative in law.
but issue number 5, my lord. Issue number 5, what has been discussed here, it is against them, my lord. Right, whether plaintiff has right title interest over C scheduled land out of.
No,
this-
it has been categorically mentioned that the plaintiff cannot claim right title interest. There is no quarrel with that proposition.
Yes,
So therefore, the first prayer has not been granted in respect of a Schedule A land.
but it is also, my lord, civil code 66, section of the Assam, my lord, Assam Temporary Settled Areas Tenancy Act 71. Matters exempted from cognizance of civil code. This one is also claims of to restoration of possession under section 54A. That is also bar, according to me. It is mentioned here in the book, my lord. 66E of the Assam Temporary Settled Area Tenancy Act.
What does it say?
Yes, my lord. 54, my lord, A. Procedure of ejectment by 50 restoration of possession to tenant or under tenant ejected or whose cultivation is prevented. 54A.
By whom?
But here, my lord, without prejudice.
Did you raise that issue in your written statement? No.
No.
And if you have not raised that issue in your written statement, matter nothing. You
That
may-
is mentioned in the first line, it is mentioned,
But
not maintainable.
Ah.
It is not maintainable, it is mentioned, my lord. In
Hello.
WS, it is specifically mentioned. That issue, the suit of suit of the
Hello.
plaintiff against the defendant is
you
not
want to
maintained.
do it after vacation. Your case is otherwise, if it comes before me, it is dismissed.
Yes, yes, my lord.
You have no
Your
case.
lordship has to hear the matter.
You may
but I
stay with-
here.
Tell your clients. Nowadays, you can't even tell. They will see out there in the live streaming also. But your client should also anticipate. If it comes before me, next time it is goes. Mr. H. Das, the Learned Counsel, appearing on behalf of the appellant, seeks for a further accommodation in the matter, which the matter after vacations.
My lord, this is a case against concurrent finding of both the learned court below. My lord. Page 8 is the substantial question. Question
Eight?
number 8. Question number 8 is the one is relevant in this case, my lord.
Yes.
My lord, the present respondent matter, as plaintiff has filed a suit in respect to the same suit land, my lord, against the present appellant, my lord. And the suit was decreed against the decree first appeal was prepared. It was also upheld, my lord. And in the RSA, it get maturity, my lord.
The suit for permanent injunction.
No, my lord. Respondent filed the suit for permanent injunction. Thereafter, after disposal of the suit, I filed the present suit, my lord,
Your suit was dismissed.
for declaration of right title interest. Yes, my lord. Suit was dismissed and first appeal is also dismissed. Against that, I prepared this.
And they applied the principles out there of res judicata.
They took two plea, my lord. First plea, the suit is barred by section 11 and barred by limitation.
Hmm.
It is the
Then?
difference.
But it was as regards the same subject matter.
Same subject, same party. But
And
legal-
then there was a permanent injunction has been granted on the basis of a privacy finding on the title.
Yes,
Then there are two,
But-
three judgments against you.
but my lord, right title was not decided in the.
Not necessary. Then also it can be.
Only this question in the.
You want that judgment to dismiss your appeal?
Otherwise, I have no question.
You don't have a case.
Only that question in the.
Huh?
Only one question in the.
That is not a question of law. That's well settled by the Supreme Courts.
It
You
is
see,
up to.
permanent injunctions
On
has
basis
to
of
be
the
granted
subject.
on the basis of a title.
Yes.
And
That's
when a
limits.
permanent injunction is being granted, basing on the title, maybe title had not been granted, but maybe at that point of time it was not required. There may have not been a cloud may not have been created out there. But when it is being decided that those substantive findings would obviously operate as a res judicata.
may not be necessary at that time matter, relevant time matter. That is in the year 1993 matter.
What to do? Dismiss it?
Your lordship.
Eh?
Up to your lordship. Because only that question involved.
Yes, he has referred to this judgment, na? I told you.
Yes, yes.
That 2007 SEC, that categorically deals with this aspect. That in a suit for injunction also where title has been discussed out there, that would have impact on a subsequent suit for that.
That part is concerned. I have no.
Even if in an earlier suit for injunction, there is an incidental finding on title, the same will not be binding on a later suit where title is directly made unless it is established that it is necessary in the earlier suit to decide the question of title for granting or refusing and the relief of demand. If the final decision in any matter at the issue between the parties is based by a court on its decision on more than one point, each of which will be.
That was discussed.
Where's the judgment of the earlier suit?
Yes, ma'am. That, I have not annexed the copy of the earlier.
Do one thing, you file an additional affidavit bringing on record that.
Yes.
Taking into account, I heard Mr. P.P. Dutt, the learned counsel appearing on behalf of the appellant, also taking into account the question of law so proposed, this court finds it necessary that the judgment and decree so passed by the trial court as well as also by the appellate courts in the earlier suit be brought on record by filing an additional affidavit.
For much time.
This is the matter after this
For-
on 29th of July.
Attain. Your lordship.
Concurrent.
Some issues are not decided, one issue are not decided by the trial court. And of, done by the first appellate court. Still question of. Page number, my lord, 12.
You are the defendant.
Yes, I am. Was filed for ejectment.
Where is your
for
plane?
license correct, my lord. I denied it.
Oh, this one.
He said it is division was.
Your point is on adverse possession. Nothing more than that, because that was the point on which you see, I said that
Yes,
115 won't be maintainable. And as such 6A, that was the issue. That was the only issue. Other issues are not there.
I have taken.
Other issues are questions of facts. 6A, what is the issue on adverse possession? And now you are raising that issue. Whether he could have decided the issue number 6A.
But here I have to raise the question of point. The lordship will see the, my written statement, then it will be clear. Here, my lord, page number 20. So, page number 20, there are 2 and 3, your lordship will see. The schedule of beat number such and such does not speak of the transfer of the suit premises, the lane schedule of the deed does not speak the sale of the standing substance standing on the lane schedule. The suit premises has got independent identity and existing. It has one construction, the document which does not contain the independent consideration money of the sale of the premises cannot treat it as a sale of the suit premises. Down I have taken, my lord. The law point is involved here.
Now tell me, Madhav Das was your tenant,
And Madhav Das,
landlord.
landlord, landlord,
He was your landlord.
I was treated him as a landlord. But
Then how did you construct over his house?
I did not construct, I improved. In fact, I improved. That,
How did you enter to improve?
yes, that is the- my husband had given some money to him, 50,000, that I have stated in my written statement. And then this premises was lying vacant with his consent, my lord.
So you entered with his consent.
I have stated here, lordship. You are here. In page number 25, my lord. Page number in the middle. On 2 to 93, performer defendant. Performer defendant is was Madhav. Prove the rupees 50,000 to refund on demand by defendant and her late husband on being February in pursuance of seeking to reside on the suit premises by defendant and her husband, performer defendant, allow us to live there.
Where?
My lord, in
Without having a rent
25,
agreement of the,
page number
here they
25,
paid monthly rent.
after a few lines.
Now kindly come to paragraph 5 of page 21. That in the plaintiff had not specifically pleaded the defendant paid rent to late so and so. In first para of so and so, defendant paid so and so, so and so, so and so. Then to the performer defendant, and the claim of the plaintiff that the defendant had been a tenant under the performer is not creditworthy. Without having a registered agreement of defendant with so and so and defying the tenant's defendant, the tenancy upon the plaintiff upon the
Then allowed.
How did you enter? Where is it?
Page number 25, my lord, after few lines. There on 2 to 93. Page number 25.
Performer defendant took rupees 50,000 to refund on demand by the Iman and her husband. During February, pursuant to seeking to reside on the Iman by the Who took the money? Who is performer defendant? Madhav Das.
From whom the plaintiff claimed to have purchased.
And when did he purchase?
purchase matter. Six. Plaintiff claim to have purchased on 8/12/2006.
Hmm?
Exhibit one,
Where,
12/2006.
who purchased?
The plaintiff,
Purchased the land and the house.
not how, our claim is that you have not purchased the house. Your sale deed does not speak of purchasing house.
What does it say?
My contention is that your sale deed, the exhibit one, does not speak of purchasing the suit premises. That is building, first floor of the building.
So you enter into possession on as a permissive occupier.
Initially, it appears from the defendant was allowed.
And how did you prove? There's nothing mentioned out there. Yes, Mr. Goswami, you were there in this matter earlier.
This is to appear in this case, but he admitted that he entered the premises with consent of the original owner.
That is there. That is the written statement.
And he has also given a notice after purchasing the land. He has been given notice by the original purchaser, notice under section as per property. Other tenant is paying rent, he is not paying.
And he has constructed the building.
No. He only.
Because
said-
he only says in his written statement, what he has done is this. I could see from here.
He paid rupees 50,000 to the original owner.
No, that is okay, but what he says is this. In the meantime, the defendant and her husband constructed water tank and installed tube well for the suit premises for use of. So you have only installed water tank and tube well, nothing more than that. Then, so it was a house. You didn't say anything in your written statement that you constructed something more than that. You were a permissive occupier. If you have entered with due permission, can it be at all a hostile at any point of time later on?
Also taken, your lordship will see my substantial question of law.
Huh?
Substantial, your lordship, page number 12,
I've seen it.
he taken the after count also.
No substantial question of law.
Here the
Whether the plaintiff is the owner of the suit premises in spite of the fact that the sale deed of the plaintiff does not speak of purchase of the suit premises. If you see your written statement, it says, what does it say? See,
Yes. Yes,
what did you say?
page number 21.
In your written statement, you categorically stated that there is a house, but the holding did not say it. Had mentioned about the holding. Kindly see here,
The paragraph 2,
paragraph 4.
paragraph 2.
The suit premises has got independent ITT and existence. It has its own construction. The document which does not contain independent consideration money of the sale of the suit premises cannot be treated as a sale. You are a third party. Who are you?
I have
You are a third party. If Madhav Das or anybody has come in out there, they can, a third party cannot challenge.
interested party.
You are not
I have
affected.
got the interest here.
The plaintiff has not pleaded. Kindly see further. The plaintiff has not pleaded anyhow where, how he acquired the suit premises for the valuable consideration. Apart from that, in the plaint of so-and-so, no number so-and-so, office speaks of the naked sale of 15 letters of the relevant dag and patta, the householding number of houses standing upon the land schedule of dag number so-and-so does not appear any selling substance. At that time, the holding number of the house standing on the land of the schedule was of deed number so-and-so, was so-and-so, and the holding number is the identity, entity, and area. The omission of the holding number of the construction of the schedule of the aforesaid resists the maintainability of the suit. The suit premises itself is valued several lakhs of rupees without producing any sale document in favor of the plaintiff cannot claim so and so. You are nobody to challenge that.
Contention is there. Premises. Sale deed exhibit 1, but not purchase.
What was sold by the sale deed? Only the 15 letters of land,
15 days are there.
not the house. He didn't say anything about the house.
Nothing is there.
Mr. Goswami?
That's if I forgot, only thing is that vendor wife has come, he has said, and holding has been transferred, he adduced evidence stating that house has been sold along with the tenanted premises. Thereafter holding,
No, what was the contents of the sale deed? Any idea?
that's if I forgot.
We do one thing, we'll have this after vacation. In the meantime, you take your instructions. File your wakalatnama. I'm not issuing notice. You know it, so you do it. Because issuing notice of this type of matter is the matter again on, we'll have it on 19th of July. This is the matter again on 19th of July. You get hold of that called the sale deed.
I have got.
Whether it considered. Otherwise, the
Holding has been transferred.
Huh?
Holding has been transferred with the name of original.
and can a third party challenge it?
No.
No, that is the law. He's a third party, and there is no challenge to the sale deed. Then, yes, Madhav Das or whoever it is, the legal representatives may very well say this was not sold. Not him.
Also,
Nobody.
vendor has filed WS. Vendor has stated that I have sold the property. Not
He cannot.
accepted.
Abhilash.
Yes,
Transformation, my lord.
service complete.
Yes, ma'am. When the response side appeared, last location took time
Huh?
to file. Response side appeared, my lord. Last location took time to file objection, my lord.
You want the transfer from where to where?
Hojai Shankardev Nagar to my lord.
To Murigaon? Why?
But there is earlier occasion also in the same incident. Earlier occasion also, my lord, in the same incident, the judicial separation petition was filed at the Hojai, my lord. Same was transferred by this honorable court, my lord. And subsequently, my lord, the present respondent will do that petition, my lord. But it was being
Again, he has filed.
yet, my lord.
Where is it? My order? Oh, this one. So this was withdrawn. Then he filed again for judicial
So,
separation,
my lord, I can file for divorce.
for divorce in the same place.
Aye.
Is an application. What about the service?
It's complete, respondent appeared, my lord.
None appeared.
Last occasion also took time. to
Is
file
an
the
application service affidavit to be filed by resident not yet received by the concerned section. What affidavit? Somebody represented?
Yes, my lord.
Okay. This is an application filed under section 24 of the Code of Civil Procedure 1908 for transfer of title suit D, title suit bracket D, number 82/2022 pending before the Court of the Learned Additional District and Session Judge Hojai, Shankardev Nagar. Full stop. It is the case of the petitioner that the petitioner is resident of, is presently residing at Jagi Road in the district of Morigaon. The petitioner was married to the respondent on 5/7/2018 under the Hindu rites and rituals in the district of Morigaon, Assam. After solemnization of the marriage, the respondent took the petitioner to the house of the respondent at Station Road, Lamding. And they were residing as husband and wife together. Thereupon, on accounts of some matrimonial feuds, the respondent came back to Jagi Road and was residing at Jagi Road and have been residing at Jagi Road since then. Full stop. the petition, the respondent, the petitioner have come back to here and have been residing so and so. Full stop. The respondent herein thereupon filed a title suit in the court of the additional district and session judge Hojai, Sankardev Nagar for judicial separation under section 10 of the Hindu Marriage Act 1955, which was registered as TS bracket judicial separation number 70/2019. Full stop. The petitioner thereupon filed a transfer petition before this court, taking transfer of the said TS judicial separation number 70/2019 from the courts at Hojai to the court at Sankardev Nagar, Hojai to Morigaon. The said transfer petition was registered and numbered as transfer petition C number 16/2020. By an order dated 19/1/2021, this court had transferred the said proceedings, that is transfer TS judicial separation case number 70/2019 from the court of the additional district judge Hojai Sankardev Nagar to the court of the district judge Morigaon. Subsequent thereto, the petition respondent herein have withdrew the said proceedings, being title suit judicial separation case number 70/2019, and thereupon instituted title suit bracket D number 82/2022. The petitioner, upon receipt of the said summons, again has filed the instant petition, being aggrieved, filed a petition that it would be inconvenient on the part of the petitioner to again participate in the said proceedings. You're transferring it. You're there?
My lord. Otherwise, Lordship, my lord, your Lordship, in earlier occasion, in one case,
Which case?
Lord, in that case, I appeared as the my lord. That's because there was no family court.
Here it was earlier also transferred.
Yes.
This court had heard the learned counsels appearing on behalf of the petitioner and also the learned counsel appearing on behalf of the respondents. The reasons for which this court had earlier transferred the proceedings title suit judicial separation case number 70/2019 still exist in the instant proceedings. And as such, this court is of the opinion that the instant proceedings, that is title suit, case number 82/2022 is also required to be transferred from the court of the additional district judge Hojai Sankardev Nagar to the court of the district judge Morigaon. Taking into account that the parties are duly represented, they are directed to appear before the learned court of the district judge Morigaon on 29th of July 2024. The petitioner herein is given the liberty to file her written statement on or before that date. বাকি খিনি সেই তাতে আছে দি দিব disposed.
Okay.
NK কলিতা এপিয়া কৰিছে দেই ৰেসপন্ড. Yes.
Pendant number 126 in the title suit number 16 of 2023. The defendant number 126.
What are you challenging?
Filing WS Lordship.
Why didn't you file it?
Lordship, on 5/9/2023, we have given an adjournment petition and it was allowed. And later the date was fixed on 5/10/2023.
Hmm?
5/10/2023, and on 5/10/2023, we have filed WS.
You filed WS.
5/10/2023, but 90 days has been expired, so
Where is that order?
Annexure 3, Lordship,
Page?
page 29.
Jointly filed. However, it is seen that a summons upon the defendants were served on so and so. Therefore, the limitation, the suit shall proceed. So 510. Okay. Heard Miss so and so, the learned counsel appearing on behalf of the petitioner. None has appeared on behalf of the respondent on call. So, the instant proceedings under Article 227 of the Constitution has been filed challenging the order dated 5/10/2023 passed in title suit number 16/2023, whereby the learned court of the, which court?
Learned Munshi Baksa.
Munsif Baksa had rejected the written statement filed by the petitioners. Petitioners, on the ground that the written statement was filed much after the filed beyond the period of limitation as stipulated under Order 8, Roman 8, Rule 1 of the Code of Civil Procedure 1908, for short, the Code. Gustav. This court duly takes note of that on 5/9/2023, the learned trial court, by the order dated by the order dated by the order, had permitted the defendants number 1 to 6, who are the petitioners herein, to submit the written statement on 5/10/2023. Under such circumstances, this court is of the opinion that the learned trial court could not have then refused to accept the written statement which was filed on 5/10/2023. Accordingly, this court therefore interferes with the order dated 5/10/2023 and directs the learned trial court, that is the court of the Munsif Baksa, to accept the written statement filed by the defendant numbers 1 to 6, who are the petitioners herein, and thereupon proceed with the adjudication of title suit number 16/2023. This court further takes note of that by an order dated 24/11/2023, the further proceedings of title suit number 16/2023 was stayed. The said stay order stands vacated, and the parties herein are directed to appear before the learned court of the Munsif on 22nd of July 2024, and the learned Munsif and the learned trial court shall thereupon proceed with the adjudication of the suit in accordance with law. Yes, what is this?
Initially, the trial court rejected the injunction order, my lord, but appellate court granted the same, my lord. Against that, we filed this revision.
Where is the trial court's order?
Trial court order at page 40.
40?
Starts from 38. Actually, this suit has been filed over a government fishery land without making the government party, and they are claiming occupancy tenancy right. Non-evictable in the prayer in the main title suit.
Where is the injunction petition?
Injunction petition page, my lord. Next up 3. Sorry, not annexer 3, annexer 2. Page 21. Title suit in miss case number 37 of 22. Page 21.
So what is wrong?
Wrong is that, my lord, kindly see the suit filed by the plaintiff in page 16, my lord. Decree declaring that plaintiff are non-evictable occupancy tenant in respect of the suit land.
Okay.
And this land, admittedly, this land, a fishery land, and it is a government fishery, over which the government has allotted the fishery in favor of the defendant, son of the defendant number 1. And there is a establishment of hatchery also there over the schedule 2 land.
Then why is the government not coming?
And my lord, they are not make party in this case.
Yes, State of Assam is made a party
In the suit,
in the suit.
in the suit.
Yeah.
In the injunction, there was no party.
The
In the injunction,
DFDO is also a party. Then?
In the injunction, kindly see
The injunction is only sought against you.
against me.
Then-
Against me. Now, kindly see, there is an, in the appellate court order, kindly see, here they are claiming that non-evictable tenant over the suit land, my lord, occupancy right. Whether it is permissible, non-evictable occupancy right. And on the basis of it is an agriculture fishery land.
Who is in occupation?
I am in,
You are in possession.
yes, because government has allotted me, we are running the fishery.
Who is in possession?
Lordship, in Schedule 2 land, he is in possession, and my prayer in injunction petition was that not to change nature and fisher of the Schedule 2 land, Lordship. And fishery is not a government fishery, it's a, with the help of government, a project of government, and he is running the fishery with the help of a project of government, Lordship. Lordship may take
Who is running the fishery?
petitioner, Lordship.
Yeah. It is on the basis of a government order.
Government sanctioned some money and for a project, and he, with that money, he is running the fishery within 3 katas of land. But my prayer is, he's admitted that within Schedule 2 land, 5 katas land is him. But the fishery is running within 3 katas of land. And the appellate court made injunction only to not to send nature and fisher of that 3 katas land, because with that injunction, fishery, no hamper will be made in the fishery. Lordship.
You have been only given for these 3 kathas of land.
Entire
your order?
fishery- Entire fishery,
Where is your order?
I have not annexed, but in the objection, it has been stated, my lord.
You have not enclosed it, Nehru. Why you have not enclosed if it is so, if it is your prayer? Otherwise, we don't find any ground to interfere.
My lord, in the court below, I have submitted all.
Court below, then go to court below.
My lord, kindly see the objection at page 31. The defendant.
No, I'm
number
not
one-
looking into all this.
Defendant number 1 accordingly
Sorry.
applied for same and got the said grant.
You
District
should have
fishery officer-
enclosed on the basis of which you have done it. And how are you filing 115?
Not 227 is there.
227, nothing. We are not going to interfere with all this. Order.
My lord, one of, I'll file additional affidavit incorporating the all documents.
Schedule 2 order is,
Our schedule two, my lord, and hatchery was established at the sanction of the government fund. And other part
so
of the
they,
fishery, other
how
part,
are you occupying that?
other part of fishery has government allotted to the son of the dependent. And hatchery is running by the dependent. Dependent is the
I'm
mother.
not on that. How is the government involved?
This is a government fishery.
If there is so, there must be a government order.
And I will produce the document.
So, you have not produced it. You don't have
my-
your case then.
My lord, may I pray for additional affidavit, my lord?
File it. How
Lordship,
many? 1 month, 2 months, 3 months. I'm not extending the interim order. I'm not satisfied. Is the matter after 2 months, 3 months, 4 months?
After, within 2 weeks, my lord.
Is the matter after 19th of July, on 22nd of July, 2024, at the request of Mr. S. Submits that he would be filing an additional.
But stay was not with respect to entire, stay was only.
I've
with
seen it,
respect
only schedule 2,
to-
nothing doing.
Because schedule two, I am constructed, hatchery, it is running by me.
Do whatever you, this is, I'm not satisfied. Without that document, there is nothing.
I
Should have brought down the court. Let us, I'm not saying it.
Well, by the last order, I was directed to file evidence in opposition, my lord. But I could not file because, my lord, the opposite party, he went outside with his father for kidney transplant, my lord. He has not yet returned. Maybe today or tomorrow he will return back. And, my lord, by 29th, if your lordship fix the matter on 29th or after summer vacation, my lord, in the meantime, I will file the evidence in opposition.
You ever stay?
Stay, my lord.
You want the transfer? Why?
Because the marriage solemnized in Dibrugarh. Marriage was solemnized in Dibrugarh first. Then I am a poor lady also. I am residing Duliajan. I am residing Duliajan. It is not possible me to come from Duliajan to Abhayapuri. And
It is in Bongaigaon.
Abhayapuri. Abhayapuri, Bangagaon. That's why petition, divorce petition filed in Abhayapuri.
Suit of divorce?
Divorce, my lord.
You don't want it.
My lord,
You don't want the divorce so soon.
my lord, I want the divorce, my lord.
On the earlier occasion, this court had granted time to the counsel for the respondent to file their affidavit. Back a month's time was granted. However, today also no affidavit, no, there has been no affidavit filed. And the counsel for the respondent therefore seeks for an accommodation. So for the end of justice, matter stands adjourned to be listed again on 23rd of September 2024. Interim order passed earlier shall continue till the disposal of the transfer petition.
But sir, in the meantime, my lord, I will file evidence in opposition.
But
In the meantime,
that is your lookout.
Or
Maybe,
Yes,
maybe your lordship indulgence. This is a transfer petition. I'm appealing for the respondent one. We have filed the wakalatnama, but unfortunately our name hasn't been shown.
which matter transfer?
It hasn't been transferred. Actually, there are two cases of filed in two different tribunals as under the same Honorable High Court. There's one is case number 1617 of 2020, and the other one is MSC case number 141 of 2020. The
Which
one
was filed
one is
first?
filed before the Gwalpara, the other one is filed before the Kamro.
Which is the first one?
My honor, there is a twist in this. The first file case is 141 of 2020, but I am appearing on behalf of the case 1617 of 2000. That is
Who
which
are
will be
you?
filed 2 days after. But there is a twist is like that. We have approached this honorable court with inclusive of every claimant. We inclusive of
Who are
every
you?
claimant.
You are
and
one
it is a-
forty-one.
May I please allow?
You belong to 141.
I belong to 1617.
You
We
are
undoubtedly
filed
we
here in
filed 2 days
Guwahati.
afterwards, but
Your
we
file is at Guwahati
filed in
and-
Guwahati, but
and the
we have
other is at Gwalpara.
Rather, but we approach this honorable court in a very inclusive way, is a comprehensive representation of all the claimants. But the first one, which has been filed by only of 2 days, they have approached the court with some malafide intention. I do not know. They have
Who is
haven't.
that?
May I please, lordship?
Ramila Rabha and Runmoni Rabha.
Ramila Rabha,
They
yeah.
are wife and Jagat Rabha and who died?
Yeah, it's died the son. We have approached this court. In our case, the claimants are the mother and the wife. But in that case, it is on which has
Claimant is the mother and wife.
wife.
And who is Bonali Rabha?
Well, actually, it's happened like that, both the same persons, but for some reason or another, it's an alias, only the name has been changed. It belongs to the same person. Later on, we have.
Do you mean to say that Runumoni Rabha and Bonali Rabha are one and the same
One
person?
and the same person, Mao.
I'm appearing on behalf of Mr. C. Fukon.
So in the case, most important thing is that we have approached this court. We very honesty, we have made both the parties. It's the mother. And
Where is Mr. Sifukon?
He is on legs in court number 7. So,
No, Mr. Goswami, the case is, we can very well apply the same principles like the Ghaffar Ahmed's case. So there wherever it is the first place where it is being filed, it will go there.
So, my lordship, only my humble submission is that my lordship is very correct, have an unfettered wisdom in this respect. But only thing is that their case, what they have filed, it is in a piecemeal. It is only the fragment.
Whatever may be, I'm not concerned how they have filed it wrongly or rightly. You have to transfer one case to both the cases into one place.
So my,
It is against the same accident.
It's against this on
Same claim, it cannot have 2 or 3. So it will be put to the one which is in the first one.
So my lordship, again, my submission is that one thing I think is that we have, I can understand the technicalities, I can understand all those proceedings. But thing is that so clandestinely, so with that they have done that it is the other cases done argument stage. So we not filed this case before this honorable, before the tribunal, they have been attending the judgment and the case already multiplicity of the proceedings would have been
It's
there.
okay, that
But
judgment has not happened, na?
It
I
has.
stayed it.
So my lordship only thinks that there, I can understand the facts, but my perspective is that there's some reasons maybe there. I just, because it's a social legislature, I'm talking from that aspect, because what happened as they have not made a party and the mother they have been not mentioned anything about the mother and who is very much, but so we can, from that, we can say they have approached the court. Of course, I don't think they have, of course, with the mentioning the equity and the honesty before this honorable court, and which is very
Who?
important. I'm talking of the other party, the which has been filed.
Aha. We are not concerned with all those things. Here, who has filed whom? Who are the 3 persons out here? You are appearing for 1 and 2.
1 and 2.
Who is number 3?
The 3, 1 and 2, we are appearing for the 3. Actually, what happened? It's the same person. The name has been different.
How is it possible that somebody else is filing in the name of somebody else?
So, my lordship, we
will have a CBI inquiry.
Yeah, yes, my lordship.
An inquiry out there. Yes, the police, let the police investigate this aspect. How is it possible that 2 persons have filed? Because these are something gross illegalities are being done, and somebody is filing it. There are 2 claim petitions being filed by the same person. It can't happen like that. Best is to, now what about number 3 service? Let us see how is it.
They haven't appeared before this court because
Notice upon
guess
respondent
that
9
the
months
justice and everything has been served, notice has been served.
Oh, her name is Bonali Rabha. In the proceedings out here, you have wrongly mentioned it as Runmoni Rabha.
So we haven't verified that, but as.
No, this is what is the report from the Dusty. Your person who was the informant, Mr. Ujjal Rabha, was the informant of the accident. He said he received this notice on behalf of one is the respondent number one, Ramila Rabha, for whom you are representing. He further stated that we have made a mistake in mentioning as Runmoni Rabha. It should have been Bonali Rabha, which have been filed.
That's the genuine mistake. If it's-
And as such, he therefore stated that Bonali Rabha's thing should be, we are making due correction out here.
Look, we can understand that there's a genuine mistake, my lordship. But my lordship, my thing is that only my request before your lordship is that this apart from technically or whatever, but thing is that my lordship, we came before this honorable court, taking both the parties. Is they have filed a case there, and that.
Who filed the case?
I'm talking about the other case, the same person. Therefore, without making the mother a party, so that is a very fragment. That is a.
Mr. Goswami, I'm failing to understand. In the case filed out there, the wife files it
Obliged.
at Gwalpara. The second case is being filed out here
Obliged.
at Guwahati, which is being done by the mother-in-law and the wife,
Right, obliged.
isn't it? So it should be in the interest of you to have it where? You want to do it in Guwahati?
Guwahati.
It is done, which is filed first or second?
Second. Second, only my submission is that though it is a file second,
Okay,
it is a full case.
okay, we allow this to. This is an application filed under section 24 of the Code of Civil Procedure for transfer of MSC case number 1617/2020 pending before the Court of the Motor Accidents Claims Tribunal number 2, Kamrup Metro at Guwahati to the Motor Accidents Claims Tribunal, Gwalpara, Assam, in connection with MSC case number 141/2020 or vice versa. It is this court have duly taken note of that the incident that both the claim petitions arises out of the death of one Hidoy Rabha Good stop. The respondent number one herein is the mother of late Hidoy Rabha, whereas the respondent number two is the wife of late Hidoy Rabha. This court have also taken note of the dusty service which have been affected by the insurance through the insurance investigator. And while affecting the dusty service upon the respondent number 1 and 2, the person who received on behalf of them categorically stated that the respondent number 2's name was wrongly incorporated in MSC case number 1617/2020 as Runumoni the Rabha, which ought to have been Bornali Rabha. Mr. R. Goswami, appearing on behalf of the respondent number 1 and 2, submits the respondent number 2 and the respondent number 3 are one and the same person. However, if the villages of those two of respondent number 2 and the respondent number 3 are taken note of, along with the address, it will be seen that the address of the respondent number 2 has been shown as resident of village Gathiapara, PS and PO, Dhupdora in the district of Gwalpara, whereas the respondent number 3's address have been shown as village Nagarpara, PO and PS Krishnai in the district of Gwalpara. The pin codes are also different. It has also been submitted by Mr. R. Goswami, the learned counsel appearing on behalf of the petitioner, respondent numbers 1 and 2, that the MSC case number 1617/2020 was filed 2 days after MSC case number 141/2020. This court, however, fails to understand why there has been a wrong mention of the address as well as the names. Under such circumstances, this court is of the opinion that an investigation is required to be carried out. Any government advocate? No government advocate? Mr. T.R. Gogoi. Mr. T.R. Gogoi, the learned counsel, learned government of Assam counsel, is requested to aid this court, assist this court in the matter. So, the SP, the Superintendent of Police Gwalpara, is directed to make an investigation as regards the whereabouts, as to whether Srimati Runumoni Rabha and Srimati Bornali Rabha are one and the same person. Taking into account that their addresses are different, as stated in the claim petitions. This court fixes this matter again on 7th of August 2024. In the meantime, a report is submitted by the Superintendent of Police, Gwalpara. Mr. T.R. Gogoi, the learned counsel, government counsel, is directed to inform the SP, Gwalpara, to do the needful. A copy of the incident order be served upon him by the registry so that he can duly facilitate the information and get necessary instruction as directed herein above. The interim order passed earlier shall continue till the next day.
Hi.
The petition seeking transfer from the court of additional district and session judge Karimganj to the.
Why you have not filed your affidavit of service?
We have filed it on 21/6.
Huh?
This note pertains to 26. They filed the affidavit on 21/6.
Mr. S. Dr. The learned counsel appearing on behalf of the petitioner submits that the affidavit of service have been duly filed on 21/6/2024. List the matter again on 22nd of July 2024, bringing on record, and the registry shall bring on record the affidavit of service, as well as also give an update as regards the service so meted out through a usual and registered post. In the interim order passed earlier shall is the interim order passed on 17/5/2024 stands extended till the next day.
Objection.
Please, your lordship. Lordship, as per office note dated 26/2024, service is complete, lordship.
Service is complete?
Yes, sir. Office note dated 26/2024.
You see, the matter now is pending before the Supreme Court. Huh?
Yes, lordship.
Let's have it after some time then.
Lordship.
Service is complete.
Lordship.
Like X to put us here. The service is complete, however, the respondents are not represented. Treated as it may, for the ends of justice, the matter stands adjourned to be listed again on 23rd of September 2024. Interim order passed earlier shall continue till.
Mr. Wen,
My lord, I am appearing for the respondent.
What is the matter about?
Lordship, they have come against the ex-party vacation order was that they reviewed it and reviewed was dismissed against that count. Will file affidavit, lordship, 1 week allowed.
None appears. None appears on behalf of the petitioner on call. However, Mr.
SD Prasad.
appears on behalf of the sole respondent. For the ends of justice, the matter stands adjourned to be listed again on 12th of August 2024. The interim order is extended till then. it is made clear that if the petitioner is not represented on the next date, the instant petition shall be dismissed for non-prosecution.
Orders.
None appears on behalf of the applicant on call. It is seen that on the earlier occasion also, none has appeared on behalf of the applicant. Full stop. Further to that, taking into account the order dated 10/6/2024, wherein also it has been mentioned that if the circumstance none appears on behalf of the applicant, the instant application would be dismissed for default. This court dismisses the instant review petition on account of non-prosecution. Yes, you have not paid that amount.
They kindly have the inspection, madam. They have prayed for further 3 weeks time, it will be done. They have sought for opinion from the AG has given the clearance. They were of the apprehension that madam, there will be a floodgate and all madam, the AG has madam given a clearance.
No, there is no floodgate. I made it
Yes,
very
very
specific in my
madam,
order.
yes. After madam, immediately on the reopening madam, in the meantime, they will.
Mr. B. Gogoi, the learned counsel appearing on behalf of the Health and Family Welfare Department submits that that the process for the purpose of releasing the fund of rupees 1 lakh, 1 lakh, na?
Yes, 1 lakh.
As directed by this court in its judgment and order dated 22/12/2023 has already been streamlined. He therefore submits that 3 weeks time may be granted in that regard. So list the matter again on 29th of July 2024. In the meantime, on the next date, the Standing Council for the Health and Family Welfare Department shall produce the details as regards the release of the funds. Otherwise, you are being getting the benefits, that benefits have been given.
They are asked me to appear in the GMC on 2 occasions. I could not arrange the funds and therefore I could not take my daughter.
No, otherwise she has gone out there and there has
She's
been.
not, yes, for the Garang physiotherapy and all, she's going regularly.
Yeah,
you know,
she,
that
no,
is
she is getting
And
an,
what-
because every month I'm getting a report. Yeah.
Lordship,
As
one
if
more,
this
just
matter is,
and meanwhile, perhaps the 6 months period will also expire. They could also look into that.
Yes,
The
yes.
stipend
10
which
months
is to be
fine.
given
That
after
was
6
indicated,
months.
madam. So
Approximately
madam, I will madam furnish instruction regarding the 10,000 also, madam, the
That
stipend.
every month.
No.
Within
she's
6
required
months.
to be
So,
given.
on the, so, Mr. R.H. Chaudhary, the learned counsel appearing on behalf of the petitioner, have also submitted that that the amount of rupees 1 lakh was only for the purpose of taking care of the immediate necessity. However, there was a direction also to pay the minimum.
Minimum wages, Your Lordship. As per direction
However,
number
there
1,
were a further direction to the effect that respondents shall pay
monthly stipend, Your Lordship, at minimum
monthly
wage.
stipend as directed in paragraph number 30, Roman 2,
31 and 32.
31,
Yeah,
31
31.
and 31, 30 bracket 1 of the judgment and order dated 22/12/2023. Mr. B. Gogoi submits that the same would also be streamlined within this period.
Lordship,
তার
possibly-
পিছত সেইটো লাইনটো লাগিব। The Standing Council for the AS shall give an update on that and also as regards the release of the rupees 1 lakh as directed in the judgment and order dated 22/12/2023.
Lordship, perhaps the name of the Standing Council Social Welfare Department may also be reflected because they were also required to provide certain
Yes,
ortho.
that wheelchair and
orthopedic
all.
repairs, the wheelchair and the device support.
Have you placed it before them,
Lordship,
the
they were,
DLSA? That
there
has
was
not
no
been
DLSA
placed. No, you place it through them. No, then only things. Anyways,
I'll ask
you in the meantime, Just file, you need not catch hold of him also, you just put it what has not been done and bring it.
A small report.
No,
today.
no, you just put it by way of a some application and I'll pass the order.
29th I'll do it.
Yes, yes.
I'm deeply obliged to you.
The communication so submitted by Mr. B. Gogoi is kept on record and marked with the letter A. We start with A.
I hope not. I hope not.
Otherwise, we only expect 3, 4 documents, so we make it from X, Y, Z and ZA. But now taking into account the matter again comes back, so making it from A. Okay.
This case, Lordship, we are directed to take step upon respondent number 7, Lordship. Thereafter, we are saying that appellant and respondent number 7 jointly file written statement. And learned friend will appear for
Appellant and respond number 7. You are the appellant.
yes, sir. He is defendant number 3, Lordship, respondent number 7. Perform.
So the appellant, you are the defendant number 1. You and file together.
Lordship, I could not file my Ukalatnama today in
Who are you?
system. My name is not showing there.
Defendant number, Lordship, respondent number 7.
Okay.
She wants to file Wakalatnama, but Lordship,
Okay,
CIS system
My name
only
is
The
shows.
service upon the respondent number 7 is complete. And Ms. So-and-so duly appears on behalf of the respondent number 7 and submits that within 7 days her power would be filed. So taking into account that the LCR has been received, no? Received, the instant second appeal be listed for hearing in its usual course. Liberty is given to the parties to file application for early hearing.
17.
What is this?
But in this case, the appellant, the original appellant has expired and we have filed a substitution application with that.
But it is still in defective.
Yes.
You have not
We
done.
have given the Wakalatnama, but it is not updated.
I'm not concerned with it is still defective. Interlocutory application
what
being
has
so and so filed by the LCs for the appellant is still lying in the filing section at defective stage. And printout copy case details of the case IC may be perused in flag X to put it here. Yes, X. 6 to the objection Wakalatnama of the impleaded appellants required.
We have.
Mr. A. Ganguly submits that that in the meantime, the defect has already been cured by filing the Wakalatnama, list the matter after vacations.
But in the
Service complete.
service complete.
Service complete. LCR received list the matter for hearing in its usual course. Liberty given to the parties to file appropriate application for early listing if so advised.
So in item number 19, they have filed, they appeared through KVA.
So therefore, it's okay. Listing it for hearing and giving you liberty to file application for early hearing.
Most of
20.
Please, Lordship, in this case, Lordship directed us to take justice service. The Lord, in fact, we took the service, my Lord, but then if he has a respondent number 2, my Lord, is expired. So we have to substitute him.
Huh?
1 and 3 we could serve, but 2 has expired. So the affidavit has been filed today only, but it's not on record.
You have filed the affidavit.
Today, my Lord, today it's been filed, but it's not on record.
Received justice from a respondent number so and so. Affidavit of not filed. You are appearing for?
I am appearing for respondent numbers 1 and 3.
2 had expired.
2 has expired.
Who are those related? Are they related?
Related.
Who are they?
Related. 1 and 2 are the brothers and 3 is the mother.
1
and 2 are the
Where is
brothers.
3?
3 is the mother.
1
1 and 2 are
Three.
brothers, he is expired and
He has a son and his wife and a daughter, but his wife is also not there, but then this live in a different place, so we have to.
Two expired.
Who expired?
You know their names? The
No.
legal heirs' names? We have it next to the reopening. You get the names and give it to him. He will file it. Mr. So-and-so appears on behalf of the respondent number 1 and 3. It is noticed that the respondent number 1 is the brother of the respondent number 2. And respondent number 3 is the mother of the respondent number 2. Full stop. The learned counsel appearing on behalf of the respondent number 1 and 3 is directed to provide the names of the legal representatives of the respondent number 2 who had expired on
Date I'm not sure.
had expired. Full stop. As well as full stop. He is also directed to provide the date of the death of the respondent number 2. Full stop. List the matter on 22nd of July 2024.
April.
Or this matter,
My lord. Petitioner number 1 has already died and it is implemented, executed the legal heirs. And petitioner number 2, the attorney holder, my lord. Admittedly, the petitioner number 1 is the tenant of the respondent, my lord.
yes, you didn't file it. You didn't file any application on 5/6/2023. This is the report of a judge. Oh no.
That I have filed this, original is in my hand, my lord. It is returned by the court to me. The court has not accepted any petition, my lord. And it is returned to me and that petition is in my hand, my lord. Here it is the original petition, my lord.
Okay. Then we do one thing. You want to file an application? Go and file an application.
What is that? It is already dead, about 7-8 months gone, my lord. I have the properties there, about 1 crore properties, my lord. I am having some clothes there, my lord. All the clothes are going to damage, my lord. If an interim order is not passed to open my shop, my lord, I will be ruined, my lord. And what they have now done is see, your lordship will find that they have put a board there for sale. In my shop, in front of my shop, my lord, in the gate. Here are the photographs.
Mr. DCC Fukun, you do one thing. I'm giving you the liberty out there. Go and file an application. And I'm also directing once that application is filed, the court will consider. I cannot pass any order on that application which is not there. I am in 227. When there is a report that you did not file, I am therefore giving you the liberty to file. When do you want to file it? You want to file it on 1st of July?
May I just clarify?
1st of July is next week, Monday.
May I just clarify one thing? Manoj, he already filed an injunction application. At page 31, your lordship will see the prayer.
Whatever maybe, he wants to file an application. Let him.
That prayer is pending. What he has filed.
No, that application has not been received.
No. My lord will kindly see, just a minute. Page 31, your lordship will file. He filed an application under Order 39, Rule 1 and 2. In that application, notice was issued.
Page
31 is the prayer, my lord.
Urgent one and immediate relief is paid for pass an order to Tanigia to open the link. Okay, so this is the application.
This is the application, my lord. Now, my lord, page 34 on this application, the Learned Trial Court, my lord, issued notice. Instead of passing an ex parte injunction, issued notice.
Ex parte he did not pass. Okay.
Yes, and thereafter, page 36 is the petition, my lord, which he claims that he filed it on 15/6. Once 3/7/2023 notice was issued, his ex parte injunction was refused by the court.
Whatever
Yes.
maybe he still has pass it,
And
and
this
the
prayer
court
is-
may very well reject.
Yes.
His allegation is not that.
I'm not- I'm
No,
not-
Mr. Kaushik, his allegation is not that my order has not been passed. It's not.
No,
His
his
allegation is
petition
that
is
I
not-
filed the petition, they are
that
not
was
accepting.
Not was accepted.
So that is the only issue
Well,
we are here.
What I'm saying.
Otherwise, this court wouldn't have taken, it would have been an appeal.
Yes.
Otherwise, it's a case of appeal. So not under 227.
I'm not opposing that, my lord. What their prayer in the injunction application and the prayer in that application are same. The injunction application, it is ready for hearing. Only because the pendency of this, the CRP, my lord, the injunction hearing could not take place. We have filed our objection there.
So then
Yes.
it's the same prayer.
Same prayer.
What is going on there is that already the petitioner number 1 died. And therefore, the implement petition is pending, my lord.
But on the
Here-
other day,
here already it is implemented, my lord.
Is there any other petitioner number 2 and 3 there?
Yes, my lord.
yes,
That implement petition is filed.
How many are there?
there were two petitioners.
2 petitioner. Petitioner number 1 died. Number
One
2 is
died.
there, na?
Yes, 2 is there.
So let the court proceed
My lord.
on the basis of the injunction petition.
Yes,
So let us not take much into this.
yes.
Here, my lord. All the
It's okay,
petitions
no
are
problem.
implemented.
He is impleted.
But substituted in here, my lord, in the revision
My
petition.
lord,
But the other day, my lord, my senior friend says. that
One
he
has died.
One has died.
So one, the number 2 is already there on record.
there.
No, okay. The instant petition has been filed under Article 226 of the Constitution, being aggrieved by the action on the part of the court of the, which court?
My lord, landed Munsif number 1, Morigaon.
Court of the,
Munsif number 1, Morigaon.
Munsif number 1, Morigaon, in not accepting the petition so filed under section 151 for certain urgent reliefs. Full stop. Be that as it may, this court have duly taken note of the petition which was filed under section 151, which has been enclosed to the instant proceedings as Annexure 5. From a perusal of the state injunction, state application, it reveals that the relief which have been sought for is parameter to the reliefs which has been also sought for in the injunction application which was filed, which have been already registered as Ms. case number
52 of 2022.
52/2023. Under such circumstances, this court, it has also been submitted on behalf of the respondent herein, by Mr. B. Kaushik, that against the injunction application, objections have been duly
Right.
filed. And it is only on account of the pendency of the instant proceedings, no hearing has taken place in the said injunction application. Full stop. It has also been brought to the attention of this court that during the pendency of the instant proceeding, the plaintiff number 1 had expired. Be that as it may, the plaintiff number 2 being the the son of the plaintiff number 1.
Attorney.
He's a power of attorney.
It's see the names.
No. Arun Paro. He is power of attorney holder.
Then attorney.
Attorney.
Oh, is the attorney?
Yes.
The attorney.
Did I look into it just now?
In fact, he filed an application for substitution that was rejected. But the other day, my learned senior friend says that he filed an application thereafter also for substitution.
Earlier was filed by the advocate, not by the parties, and that's why that was disposed
That
of.
was rejected.
And thereafter, again, the petition is filed, and I have no idea about that.
Be that as it may, it is seen that the plaintiff number 1 have already been substituted in the instant proceedings by an order dated by an order dated 1/5/2024. Full stop. There was a stay in the instant proceedings?
No.
So during the pendency of these proceedings, you filed an application for substitution.
Here in the
Stop. Plaintiff number one, just 1 minute.
but that application as was filed by the council, it was rejected by the court. Advocate করেছিল? Advocate করেছিল? Party signature আছে।
Religion is substituted by law. Under such circumstances, this court permits the petitioner's hearing to file an application for substitution for substituting themselves against the name of the plaintiff number one in title suit number 77 of 2023. And the period and taking into account that in the instant proceedings, the petitioner's hearing have already been substituted. The period from the period from the date of filing of and as such, there would be no further requirement for filing any applications for setting aside abatement or, for that matter, continuation of delay. Mr. DCC Fukun submits that that the said application would be filed by 1st of July 2024. Under such circumstances, this court fixes the matter before the learned trial court on 1st of July 2024, on which date the petitioner's hearing would be able to able to file an application for their substitution against the plaintiff number one. And the learned post the substitution being carried out, which needs to be carried out on an urgent basis, the learned trial court shall proceed with the adjudication of case number 52/2023 in accordance with law, with the above the instant proceedings that disposed.
52, Madam Minister.
Obligation.
And my lord, one observation, maybe even as early as possible, the municipal.
I see. I can't say more. I waived out all other things. Yes. Yes. What is this? Delay?
An application for condonation of delay.
How much? When you are appearing, there must be much more.
No, well, earlier, in fact, the review application was filed. After the dismissal of the review, we have filed the
Where?
for the Assam report.
Was filed on demand. There have been persons who are even for review was. Yes, madam, what do you have to say?
Lord, I have no objection. I'm appearing for respondent number.
This is an application. All are represented? No objection has been for one and two. AD card has been received for 3. How many respondents?
Proforma, there is one proforma.
Performer, we strike it off. Unnecessary. You want the performer? What is this performer business? How will the performer, what is the address of the performer? Kindly come to page 2 of the application. All are residents of same. Now 3 is represented. Now 3 has already accepted. Service ID has been received. So 1, 2 and 3 is complete. Heard Mr. D. Majumdar, the learned counsel appearing on behalf of the petitioner, appellant, applicants, and Ms. So-and-so appearing on behalf of the respondent number 1 and 2. It is also seen that the service upon the respondent number 3 is duly complete. This is an application for condoning the delay of 773 days in preparing the accompanying appeal directed against the judgment and decree dated 4/8/2018, passed in title appeal number 10/2014. This court have duly taken note of that pursuant to the judgment and decree dated 4/8/2018, passed in title appeal number 10/2014. A review application was filed before the learned first appellate court, which have been registered and numbered as Mijay case number 95/2019. However, the said review application was dismissed by an order dated 5/9/2022. And thereupon, the instant appeal was filed on 7/1/2023. Taking into account that on account of the delay in disposal of the review application, and the instant appeal was not filed within time, it is the opinion of this court that the same constitutes a sufficient cause within the meaning of Section 5 of the Limitation Act. Accordingly, the instant appeal, according to the delay of 773 days is condoned, thereby allowing the instant application. The registry is directed to register the accompanying second appeal and show the name of Ms. So-and-so appearing on behalf of the respondent number 1 and 2 in the cause list. Mr. name? So-and-so appearing on behalf of the applicant is directed to serve an extra copy of the memo of appeal to along with, there's a stay application, along with the stay application, if any, to Ms. So-and-so by within 3 days. List the matter immediately after the vacations I disposed.
Please.
Delay condemnation.
How much?
Three 60 days and
3?
60 days in 1484, Lordship.
650 days.
360 days.
392 days.
In IA number 1484, Lordship.
What is 2222? 2262?
2262, Lordship. That is 392 days.
And why there are 2?
Lordship, one counterclaim is there.
This is on account of death.
Lordship. Fresh appeal.
Then
Challenging the
why there are 2 delay applications?
one counterclaim, one suit against this.
Oh, there are 2 appeals.
2 appeals. Lordship.
I read appeal, Asuni.
24, Lordship.
What is the ground? Madam, you have filed objection?
Yes, my lord.
What is your objection?
My lord, actually, they have referred two appeals and 2 condemnation petitions. But as the averments made in the earlier appeal are the same, my lord, so I have filed one affidavit contending the same and rebutting the same allegations.
Okay, now tell
Lord,
me, why are you objecting?
My lord, no sufficient ground. At page 5, what the learned friend has submitted, that they were under the impression that from a court of law, my lord, from a court of law, the expectation that I have only one piece of land, so the court will protect me. Is it a
Not only
sufficient
that,
ground, my
Lordship,
lord?
some other grounds are
And
also there,
secondly, my lord, no money. And thirdly, illness, no medical certificate, nothing, my
Because
lord.
during COVID period, Lordship.
No medical certificate, nothing.
The poor laborer, Lordship, it is mentioned that he is running a 7-member.
Page 5, my lord, paragraph 3, impression.
Para 4, I have stated the grounds, Lordship, and para 5 also.
What does the applicant do?
The laborer, lordship, laborer, lordship. His family is consisting of 7 members, lordship. Right. I have mentioned in para 4, lordship.
Where are legal, where are the medical certificates?
Medical certificate, I have not annexed, lordship.
Huh?
Medical certificate.
File an affidavit. Otherwise, your grounds are not good grounds. What you have explained more is during that period of COVID. How does it matter? After that, your only ground is for 2-3 months you were not on account of jaundice. But the problem is, how do you take care of a year?
Lordship, during COVID, I have applied for the certified copy and then I.
Understood. I'm not on that. You are to show after 28/4/2022. So 28/4/2022, what did you show? You said that you were suffering from jaundice. Very well. Now, after jaundice, what happened? The jaundice was 3 months. How do you take care till 14/5/2023? That is not explained. Ms. R. Chaudhary, the Learned Counsel, appearing on behalf of the petitioner, applicant submits that submits that she would like to file an affidavit, additional affidavit, an affidavit in reply, file an affidavit giving further details as regards the period and giving further explanation as regards the period post 28/4/2022, and if there is any medical documents, she may be permitted to enclose. First, list the matter immediately after the vacations. In the meantime, affidavit liberty is given to file affidavit.
Apply.
Yes, what mistake I have done? Review.
Lordship, I'm paying for timing of this matter, Lordship.
25.
And timing of this matter.
Till the review business.
Okay, I'm sorry, Lordship, I haven't gone through the petition, Lordship. The senior has gone through the petition.
What is the review? Or it's somebody else, not mine.
Lordship, it's earlier, Lordship, retired, your Lordship.
Huh? In my judgment.
No, Lordship. Lordship, kindly come to page number 33, Lordship.
30? Yes. What is the ground of review?
Lordship, I have not gone through the
Hello,
file, Your
the
Lordship.
counsel appearing on behalf of the applicant is not ready. List the matter after 4 weeks.
Much obliged.
Is your lordship, affidavit for Dusty has filed and the copy was.
Yes, service complete. Then,
May I please, Your Lordship? The notice has been received by the respondent, got a telephonic instruction that he will engage us, but for the timing, we request some time to file wakalatnama.
what is the matter about?
We are challenging the order
I
dated,
injunction. You got an injunction?
yes, status quo was earlier passed in this.
You have appeared before the trial court?
Lordship, I've not got the brief.
Get your instruction. We'll take it up at 3. Get your instruction or appear before the trial court on 10/7. We'll direct the status quo to be maintained till 10/7, and then you fight it out there in the trial court. Unnecessary 2 places fighting out here, that makes no sense. They came against an order by which there was no ex parte ad interim injunction was granted. This court passed an order. I want to pass an order to the effect the next date is fixed before the trial court on 10/7/2024. Go and appear there. Let the status quo which has been passed by this court shall continue till 10/7 and thereupon proceed. Fight it out. Get your instructions. 3 o'clock. Okay. Just that. Nothing more than that. Because you see, anyway, you are asking for time. Makes no sense. This court will only fix it after that. And thereby the status quo would be extended. So instead of that, go and fight out there. Isn't it? It makes more better sense. So go there, ask your person, give him a phone call. What is this?
Records of both the cases, both the appeal and the suit has come, my lord. May I come up for admission, my lord?
What is this?
Landlord tenant.
Landlord tenant. You are the tenant.
I am the tenant. I filed a suit for declaration of tenancy right. Was dismissed. Thereafter, my appeal was also dismissed.
Your suit was for?
I filed a suit for declaration of tenancy right.
Tenancy, what tenancy?
The tenancy right, I sought for a declaration.
Of what tenancy right?
Of a declaration that I am a monthly tenant under the landlord. Within the meaning of.
Did he file a suit?
That till that time he did not. He did not file any suit for eviction.
Then?
But then he had made an endeavor to oust me. So under such circumstances, my tenancy right being clouded, I filed my suit for.
Understood. Then?
Thereafter, my lord, the suit was dismissed. That I preferred an appeal. The appeal was dismissed. I have come against the.
How do you come under CRP?
My lord, in a rent matter under Assam Urban Areas Rent Control.
No, does the Rent Control Act conceive of a filing of a suit by the tenant for declaration that you are a monthly tenant?
But for eviction,
That's a different thing. That is his case. That is why I'm asking you. Does this court, is it ever conceived of? No.
For a
Take an appeal.
tenancy.
Dismiss.
Liberty.
And what is the interim prayer you are asking?
Declaring for stay of that. Why I'll explain, my lord. There is a reason, my lord.
Okay, Mr. D. Chakraborty, withdraw, liberty, file appeal if you want.
My lord, yes, of course.
Mr. D. Chakraborty, learned counsel appearing on behalf of the appellant petitioner submits that he may be permitted to withdraw the instant proceedings and liberty, however, may be given to challenge the judgment and decree passed by the learned First Appellate Court dated
2024.
12/3/2024, passed in title Appeal number 7 of the 2022. First up, this court have duly taken note of that the suit was filed by the petitioner herein as plaintiff, seeking for a decree that he is a monthly tenant and he should not be evicted without due process. The said suit was dismissed and thereagainst an appeal was filed which was also dismissed. First up, in the opinion of this court, the said appeal, the instant petition under section 115 of the code is not maintainable, taking into account that against the decree, there is a requirement of filing a second appeal within the meaning of section 100 of the CPC and not 100 of the CPC. First of, it is relevant to take note of that section 8 of the Assam Urban Area Rent Control Act 1972 is not applicable, taking into account that it was not a suit filed by the landlord. First of, under such circumstances, this court therefore dismisses the instant petition on the ground of maintainability. First, however, it is also, be that as it may, taking into account that the petitioner have been bona fidely litigating before this court, the period from the date of filing of the instant petition, that is on 18/4/2024 till date, be excluded, while excluded in the circumstance petitioner herein prefers an appeal against the judgment and decree passed dated 12/3/2024, passed entitled Appeal number 7/2022. Full stop. The petitioner here, the counsel for the petitioner is also given the liberty to file an application before the registry for the certified copies of the judgment and decree passed by both the learned first trial court as well as the learned first appellate court, which are part of the instant petition. In circumstance such application is filed, the registry shall forthwith and not later than 5 days therefrom provide the certified copies of those judgments. LCR,
Yes.
the registry shall retain the LCR for 2 months. You are filing immediately for a month, for 1 month, and thereafter return the LCR before the courts below. Yes. What mistake?
My lord, the petitioners before your lordship are college teachers and principal. They are granted, my lord, pension as per, my lord, the Assam College Employees Provincialization Act 2005. But they are not granted gratuity and leave encashment. Hence, they approach before your lordship and your lordship declined their
What?
declined their, my lord, prayer. Your
Which
lordship
prayer?
held that, my lord,
Why are you filing a review?
sir, my lord,
If I have declined, go to the appeal.
here, my lord, small, my lord,
Yes, Mr. Gogoi.
See, with cost, lordship, with cost.
Cost, na?
With cost.
How much? He last time spoiled the time of this court on 6/5,
Lordship.
and today he's again spoiling it. So don't you think that minimum taking into account the electricity charges, Mr. K. Gogoi is yeah, minimum 75,000?
Last occasion, my lords have indicated 1 lakh.
Oh, 1 lakh. So we make it 1,25,000. What is all these things?
My lord, here, my lord, only, my lord, effect of the
You want to anything wrong, go and file appeal. This is no case for review.
then, my lord, I may be allowed to tell you about it.
Yeah. Mr. A.M. Borguia, the learned counsel appearing on behalf of the petitioner submits that, taking into account that, in view of Mr. A.M. Borguia, the learned counsel submits that strictly speaking, the instant proceedings would not come within the ambit of the review jurisdiction of this court, and as such, he therefore submits that he may be permitted to withdraw the instant petition. He, however, submits that the period during which the instant review petition has been pending be excluded while computing the period of limitation. This court, taking into account the above, the instant petition stands closed on withdrawal. However, this court, the petitioner would be always at liberty to file appropriate application before the appellate court, seeking condonation of delay on the basis of the pendency of the review petition.
Obliged. Second one, liberty. Item number 25, my lord, actually we have to withdraw this. Actually, what had happened, my lord, there is a judgment of the Supreme Court. So lots of kindly have.
25 to do. Last time also matter came up.
Actually, when these people came to us, then I advised them review is not maintainable. What is maintainable is an appeal. Please have this a judgment to give. Please come to para 11, my lord, at page 410. The position emerging from this decision in regard to appeals against orders in contempt proceeding may be summarized as thus. An appeal under section 19 is maintainable only against an order or decision of the High Court passed in exercise of the jurisdiction to punish for contempt. That is an order imposing punishment for contempt. Similarly, various situation has been visualized. Now please come to Roman 5. If the High Court for whatever reason decides an issue or makes any direction relating to merits of the dispute between the parties in a contempt proceeding, the aggrieved person is not without remedy. Such an order is open to challenge in an intra-court appeal if the order of the learned single judge and there is a provision for an intra-court appeal or by etc. So, what had happened in this case? The learned single judge Millard has gone beyond the scope of the. There was an allegation that injunction order, as status quo order, has been violated. Now the learned single judge has appointed commission, etc. So many things, and even he has traveled beyond the scope of
in a contempt jurisdiction.
in a contempt. So, my lord, our remedy lies before the division bench, and it was not by your lordship. By, I think, by an administrative order, the matter has been assigned to your lordship. In fact, order is at page number.
Which order? Page 30.
232. Long order has been passed. So our only prayer is, my lord, we'll file an appeal.
No, just 1 minute. There is a
Yes.
reason why I'm saying this. That the business of
The lordship kindly comes to page 36. Page 36, my lord, for a moment. Fourth line from the bottom top. Accordingly, as a consequential relief in a contempt petition, we modify the earlier order of status quo. Status quo was granted in the RFA. To the extent that from the date of present order, that is 7/11/23, no construction, modification, renovation, or alteration in any form of the disputed property would be carried forward by the respondent party. So the order which was alleged to be.
Now, why was the contempt filed?
That of page 33, my lord, this was the order, last paragraph.
This is
16/12/22
again, say,
order.
Under 15, 12, insubordination of the
Anyway, my lord, the contempt court will decide only the contempt part. They cannot go on to the merits of the case.
because this court can pass an order if it is this court's order, no?
But in terms of that, my lord, if a lordship would kindly have the Supreme Court judgment once again. 3. In a proceeding for contempt,
So the order passed in the RFA, FHOW,
that was substituted.
that was substituted in a contempt. Better save this
When
court.
these people came to me, my lord, I said an appeal lies. So therefore you have seeking a wrong forum. Only thing is, my lord, we are bona fide because we'll have to file that within time. We are bona fide.
But I would not close it today. Why I'm saying it, there's a reason why.
Yes.
This contempt comes from a proceedings under civil jurisdiction. Whether an appeal would lie against.
No, whether first of all, section 12 petition will lie or order 39 rule 3 proceeding will lie.
Here they can file an order 39 rule 2A.
3 also.
Yeah, 2A, they can file it. But I'm saying about whether
Section
an
10 and 12
appeal,
of the contempt of court. Act.
whether an appeal will lie.
Because, my lord, because in a contempt proceeding, the court-
Because you see, what he did, he modified that order. No, if you modify the order,
that means he has substituted the original appellate proceedings.
yes, so appellate order, if you are touching it, then an appeal, will it lie? I'm saying about that. Think
No,
about.
no, because the order was passed in a contempt proceeding, therefore, in terms of para 5, an appeal would lie to the division bench. Instead of review, in my humble submission, we should have filed a review. Sorry, appeal. We have filed a review of that judgment.
Think about it. I think you have a problem with that if you do that, because he is substituting an order in a FAO. And appeal only lies to the Supreme Court.
That is also there.
So there you may have a problem. Once you withdraw here, then you may be in here.
Then if you go to Supreme Court, it's okay, but if, anyway, we'll also think it over.
You think about it.
Yes.
Otherwise, I'm inclined to review
Yes,
it.
yes.
This order can't there. But
Okay,
anyways,
we
you
come
want
immediately after the
to save me from the embarrassment. আগৰ সেই order to কাটি দিব, the council appellant is not.
After the
Mr.
vacation.
K. Chaudhary, the learned counsel, senior counsel, appeared on behalf of the appellant,
Review
petitioner, and full stop. Upon hearing the matter, this court fixes the matter again on 22nd of July. Just think about that.
Sure.
That order which you are saying has only in relevance of a contempt. No problem with that, where anything else is saying. But here, if you are touching on the FAO,
Because FAO order has been substituted.
which obviously under contempt you couldn't have done.
Deep.
Fine. If I may, my lord. My lord, service is not complete in regards to respondent 3 only.
So, why?
My lord, insufficient address. My lord,
You have given me insufficient address. Whose fault it is?
my lord, as per the previous address, we have taken steps.
Who is respond number 3? No, not নতুন case. That's the 40% disability one. This case. How will anybody get it? Kamaluddin, village Kadiman, PO Badarpura, PS Badarpur, district Karimganj. So easy. Can you trace it out? Then, what to do?
My lord, some time may be. My lord, another chance may be given to take fresh steps upon the response.
Take Dusty. Everybody is served. By the time, otherwise, if I give you another chance, a lot of people may die in the meantime.
My lord, matter may come immediately after vacations. In the meanwhile, we shall take steps. my lord.
Dusty. If the postal department can't find it, you will try and find out. Because the address is wrong.
Lord, we shall have to trace out the address.
Respond number 3 not found. Unserved notice have received back in respondent and the same has been taken. Insufficient address. We do one thing. We dismiss your appeal.
Oh, my lord.
Problem is solved. No. We dismiss the appeal. Then you need not serve. You have given insufficient address. You can't keep the appeal pending like this. Okay, what is the address? Who is he? Respond number 3 was suit Aman. Who is Kamaluddin? You were the defendant?
Yes, ma'am.
Huh?
Just a moment.
Did respondent number 3 participate in the proceedings? See? And you say that you don't know. You file the written statement together. You want to delay these proceedings? No, this doesn't show bona fide. See, page 29. Written statement of defense number 1 to 6. Then you want to delay the appeal?
No.
There is a stay to make it go. At least service will be meted out.
My lord, written statement is for defendant number 1 to 5, not Kamaluddin.
What?
1 to 5, my lord, written statement.
1 to 6. The answering defense number 1 to 6 begs to state as follows. See the plaint. Number 6 is Kamaluddin. Then?
My lord, this is typographical error.
Oh.
My lord,
Page 34. Typographical. You file your written statement together and you don't know him. And you give insufficient address. We strike out the name of defendant number 3. We strike out the name of defendant number 3. Not necessary. The respondent number 3. Because he is your person. Interesting. Good idea.
my lord, because in the written statement, my lord, in the original one, his name is struck off, my lord. My lord, in page number 34, my lord, his name is struck off, and in the
But whatever may be, the answering defense number 1 to 6.
my lord, that is written in the latter part.
Whether it has been who struck off? You struck off
My lord,
by giving a printed document.
my lord, initially we have stated the written
Nothing doing.
statement submitted by the answering defendants number
No,
1
no,
to
no,
5.
no, no.
Well, subsequently, it has been written 1 to 6, my lord.
We strike out the name of he did not participate in the proceedings.
Yes, yes.
Yes. This court have duly taken note of that the service upon all the respondents are duly complete except the respondent number 3. Mr. So-and-so, G. Imtiaz.
Yes.
Appearing on behalf of the appellant, submitted that the name of the respondent number 3 may be struck off, taking into account that the respondent number 3 was a co-defendant who never participated in the trial or even in the appeal proceedings. Taking into account the above, the name of the respondent number 3 is struck off. It is also seen that the service upon all the other respondents are complete, as well as the LCR has been received. List the matter for hearing in the appeal for hearing in the usual course. So liberty is given to the parties to file an application for urgent hearing. The counsel for the appellant is directed to file an amended memo of parties before the registry within 3 days from today. And the registry shall, on the basis of the said amended memo of parties, shall, and as well as the instant order, make necessary correction in the cause title, as well as also update the same in the CIS. I condemn. The instant application is an application under Order 41 Rule 5 of the Code of Civil Procedure 1908 for staying the operation and staying the judgment and decree dated 19/12/2023 passed by the court of the learned court of the District Judge Karimganj in title appeal number 02/2014. So it is noticed that the respondents have not appeared. Oh, you have not taken steps here. It is taken note of that no steps have been taken by the applicant. Mr. G. Imtiaz submits that he may be given an additional opportunity to list the matter again on 22nd of July 2024. The interim order so passed on 6/5/2024 stands vacated. And upon service and shall be again, and the applicant herein would be permitted to make submission for reconsideration, submission is vacated, and the applicant herein is given the liberty to make submission on 22nd of July 2024, subject to effective service upon the respondents on or before the next date. This is an appeal. Heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner, appellant, and Mr. So-and-so appearing on behalf of the respondents. Brother, fight between two brothers.
Yes, yes, Lordship.
The instant appeal has been filed. Being aggrieved by the non-granting of an ex parte ad interim injunction by the Court of the Civil Judge Senior Division Dorong Mongoldoi in Ms. case number 13/2024, arising out of title suit number 14/2024. Full stop. The respondent herein is duly represented and have also been, and this court have been apprised that the respondent would be appearing before the learned trial court on 10/7/2024. Under such circumstances, this court would not like to further continue a parallel injunction proceedings before this court. Taking into account that the petitioner herein and the appellant herein have been granted due protection by an order passed on 31/5/2024 in IA Civil 1580/2024. As the respondents would be appearing before the learned trial court, this court therefore disposes of the instant appeal, thereby directing the learned trial court to dispose of the said injunction proceedings within the time being Ms. case number so-and-so Ms. J case number 13/2024 within the time frame. The injunction order so passed by this court on 31/5/2024 in IAC 1580/2024 shall continue till the disposal of Ms. J case number 13/2024. It is made clear that the learned trial court would be shall decide the said injunction proceedings in accordance with law and without being influenced by the order dated 31/5/2024 passed in ISC 1580/2024 or the instant order so passed. I stands disposed, yeah. Collectively.
SNR two has appeared. We have entered APN Lordship, we will take some time to file APD opposition, Lordship.
Have you paid that amount?
We'll file a reply, your Lordship.
What reply? You were directed to pay the amount. Ask your person to be appearing before this court tomorrow. Where are these people from?
From Guwahati.
Tomorrow. Day after, ask them personal appearance. This is absolutely a violation of this court's order. Don't come up with all this reply business and all. There was a specific direction passed by this court. What was the direction? However, we are inclined to impose a cost of rupees 50,000 jointly and severely on the petitioner number 2 and 3 for annexing an unreadable and illegible Annexure 10 and for providing partly typed Annexure 10 and concealing of 2 later pages of the said document which can be read unfavorable to that. It is clarified that the cost is not imposed on the petitioner number 1 society but only on the petitioner number 2 and 3. The said costs shall be deposited by the petitioner before the learned court of the civil judge senior division number so and so in the proceeding of title suit within a period of 1 month from today. On such deposit being made, the same can be withdrawn by the respondent number 1. If the cost is not deposited by the petitioner number 2 and 3 within time allowed, the respondents are permitted to take steps in this court for enforcement of costs. Last time I said it is, however, observed that pending notice the opposite party hearing would be at liberty to deposit the said amount before the learned trial court as directed in the quoted paragraph. Tell your persons we are having it on Thursday. By depositing that 50,000 by tomorrow or 50,000 expenditures plus another 2 lakhs. The learned court was clear. And second is the imprisonment. For that, I'll give you time to reply as to why you should not be sent to jail. Tell your people. Don't try to act smart, Mr. Counsel. This is something which is very serious which you have done. And then also you have the audacity out here to ask for time. You have taken things for granted. List the matter on list the matter on 27/6/2024. At the top of the list, the petitioner number, the respondent numbers 1 and 2 shall be personally present at 10:30 a.m. Full stop. This court, however, makes it clear that the respondent number 1 and 2 shall be at liberty to make the payment before the learned trial court before 27/6/2024. Don't come up with this reply business. Mr. J. Das appears on behalf of
Dear Lordship, in the I am for the petitioner, and in the main case, I am for the defendant. Here the dispute is between the wife and the husband.
Oh, that one.
Yes, Lordship. Your Lordship is directed not to disburse any pensionary benefit.
What has happened? Nobody is appearing for these people?
No, Lordship. No, Lordship. On last occasion, Mr. Ayat Talukdar appeared and he told that he will file the Wakalatnama, but subsequently he has informed that the Wakalatnama was not given to him.
On behalf of?
On
The
behalf
respondent.
of the, no,
You are the
I am for the respondent.
ONGC.
No, Lordship. The private respondent, that is the Deepika Syam.
Who is appearing for the applicant?
Applicant, Mr. S. Dasgupta. He is out of station for till August, I think.
You have not released. Is directed not to release any retirement benefits to either the applicant or the respondent till further order of this court.
Initially, we prayed for stopping of 50%, but Mr. Ayataluka, he has prayed for stopping the entire amount. So that was stopped on the last occasion.
Let us have it on some other date,
Yes, Lordship.
as none appears on behalf of, Mr. S.N. Tamuli appears on behalf of the applicant. However, none appears on behalf of the respondent, opposite party, who is the petitioner in CRP IO number 57/2024. For the ends of justice, the matter stands adjourned to be listed again on 7th of August 2024. That order is already there, no?
Lordship,
That order is already there. The ONC is directed not to release any retirement benefit till further orders of the court. So it's- এটা IA2 থাকবে। Yes, what is this?
I have filed one ILOC IA 1600/2024 to allow me to some temporary repair lordship of my shop lordship, which is situated
Huh?
for repair of my shop lordship on temporary basis lordship, which is situated at the suit land lordship. Against that, my learned friend respondent number one filed one objection lordship. I have filed reply also. Today I have filed one reply lordship against his objection lordship. That is not before your lordship. I want to do some repair work lordship, temporary work, because that is a shop of welding shop lordship, and the condition of the showpiece is not a good lordship because it is a bamboo wall and bamboo post lordship. So I want to do some temporary repair.
Annexure A, what is that? Which
That-
one is your shop?
This is my scope lordship, page 9.
Which one? With the tin?
Yes, lordship, that is, no, we have, that is a CIC and bamboo wall and bamboo post lordship.
You want what?
I want some repair of that shop lordship, because this is the shop lordship, welding shop lordship, and my family is depending upon that income of that shop lordship. That is my categorical statement lordship.
What does he say in his reply? He has given better photographs. What is
My
this?
That I have some other source of income lordship, but I
My
have,
annexer 2,
but I have,
What is Annexure 3, Roman 3?
Roman 3. This is the shop room which is situated in front of the Suitland, and this shop room is also run by the appellant.
I have denied
So-
it, I reply today.
The name of the owner.
What is this Annexure 4,
Annexer 4.
page 27?
My lord, this is the residence of the appellant, and from this residence he is running one tourist lodge. And here, next page, lordship will find that this is also part of his residence, where from he also carries out business. But in para 4, he is saying that this welding shop, which is
Has
situated
he
on
filed
the
a
Suitland.
reply against this?
Yes, today.
Today I have filed reply.
Where is it? It's not on there.
Copy is also served.
1 hour back lordship, I have filed. At
Huh?
2:30 I have filed.
After 2 PM, it is.
At 2:30 I
Okay.
have filed lordship.
Oh, okay, we'll have it after, yeah. There is no urgency.
On Thursday lordship, because
What?
monsoon season, on
No.
Thursday monsoon season is going on lordship, that's
Why
it.
did you file so late? When did he file his reply? He filed his reply on 6th of June. You filed it now. No urgency.
On Thursday lordship if possible.
Huh?
On Thursday lordship if possible.
Thursday, no. Thursday, we have fixed the contempt. Okay. It is seen that Ms. P. Bhattacharjee, appearing on behalf of the applicant, submits that an affidavit in reply has been filed to the affidavit in opposition. So, however, the said affidavit in reply is not there on record. If I start again on 19th of July, 2024.
Published.
History shall bring on record.
A3.
First time, second time?
Lordship, they have appeared. First time.
Appeared?
IL Lordship. This is.
Why are you appearing?
Lordship,
Notice was issued.
appellant died.
Oh, appellant died.
Appellant.
How much is the delay?
Delay Lordship, according to my calculation, 187 days, but
As per them, it is 232 days.
this is Lordship may kindly take up 1651 first.
54. What is 1651?
This is delay in filing setting aside. This is one.
Why this delay?
I have explained in with a 4 to 7 Lordship.
Why?
But they were not aware of the procedure to get that file. Once they came to the.
Your fault. Your fault. Why when you engage that anybody dies, kindly inform us. Why don't you inform? Isn't that your fault? So we should refer you to the,
Not expected that.
we
the
should refer
party
you
will
to the
die
bar
at that
council. Did he die of a young age?
time. No,
Then you knew it is the old fellow. You should have told if you die, this is the state of affairs. That is one of your legal ethics to do. You can't come up and said, oh, nobody knew that it was required to file and it will be continued.
in a sole appellant died. Therefore, their children came. If I say the sole appellant, then if you die, you have from us. I think.
Okay.
So, Lordship,
What is the
Explanation is not proper.
matter about?
Is
Land is how much?
it is regarding a pathway Lordship.
Pathway.
Appellant sold out a portion of land along with right to use of a pathway, and subsequently she blocked it. So this is the case
case
Lordship.
of the plaintiff. We lost in both courts. Lost in both the courts.
Lost in both the courts. So better let us dismiss it on this matter over.
Here the matter on merit,
Pay 10,000 cost. Not to him. Not to him.
but,
To him, that was not good. Nowadays I'm doing social service.
What date of death
Nowadays
is, I
I'm
think,
directing them to make payment out there to well, this Shishu Sarothi and all this. बोले था वो?
may I read the grounds?
Huh?
May I read the grounds?
No. I've seen the grounds. Doesn't inspire the
request- I
confidence of
request-
this. Can't come up with all these things. Okay, we'll do them. Impose cost upon you for not informing your client. You pay. Yes, whom do you want to pay? A lot of people. Yes, in Kamrup, we have SOS Children's Village, Assam Shishu Kalyan Sadhan for boys, late Rishika Memorial Home for Special Mission. Your only choice is where you will pay. That is the only discretion left with you.
I filed objection in this case. I filed objection in this.
Well, see, dismissing this the proper. Why so many?
One extra Lordship. 16554 is extra. Additional.
Condonation in setting aside amendment.
Donation against everything. Means one is a condonation against substitution, the condonation against
Setting aside amendment.
Well, all these four applications are taken up together for consideration. IAC number 1651. All the taken up together for consideration, taken into account that these applications have been filed on account of the death of the sole appellant on
Died on 31
18/4/2023.
as per death certificate was to 31/3/2023.
31/3/2023. IAC 1651/2024 and IAC 1652/2024 are applications seeking condonation of the and IAC 1654/2024 are applications seeking condonation of delay in filing applications for setting aside abatement and substitution of the legal representatives. The grounds which have been mentioned in the application is that the applicants were not aware of the legal procedure, that on the death of the applicant, there is a requirement for substitution of the legal representative. This court have duly taken note of the other ground, have taken note of the reasons which have been mentioned, and from the above, from the above, it is the opinion of this court that the applicants herein were kept at dark by the learned counsel in not apprising that it is the requirement of law upon the death of the appellant or any party to the proceedings having an interest, having a cause of action, right to sue, to substitute their legal representatives as and when the death, the legal representative, for the continuation of the appeal. Taking into account that it is a fault on the part of the counsel, this court is of the opinion that the delay needs to be condoned. Inasmuch as on account of the fault of the counsel, the party cannot be prejudiced. Accordingly, IAC 1651/2024 and IAC 1654/2024 stands allowed. This court, however, cannot also be unmindful of the fact that in the case of sheer negligence and carelessness, and as such imposes a cost of 5,000 upon the applicants. The applicants, the IA numbers 1652/2024 is an application. 1653/2024 is an application for setting aside the abatement. What is all these things? Order 22, Rule 3. Isn't this Order 22, Rule 9?
Full line. Full line.
1652/2024 is an application for setting aside the abatement. Taking into account the reasons for which the delay has been condoned, this court is also the opinion that it's a fit case for setting aside the abatement, else the applicants would be completely non-suited. Accordingly, IA number 1652/2024 is allowed ISC number 1653/2024 is the application for substitution of the legal representatives of the appellant, that is, whose names are duly mentioned in paragraph number 2. Taking into account that the right to sue survives on the legal representatives of the appellant, this court substitutes the original appellant by the applicant number 1 and 2 of the instant application. They would be arrayed as appellant number 1.1 and 1.2. I so and so stands allowed. This court, however, makes it clear that the instant order is subject to the deposit of rupees 5,000 as cost. The applicants herein are directed to deposit this amount of rupees 5,000 to the charitable institution SOS Children's Village. Oh, that's too far off. Where do you want to run? You stay in AKD Road?
I stay at Lokra.
Lokra, Turburi, Kahilipara, good. Snehaloy, Home of Boys? No, who will go?
Here, Lord's Garage.
Okay, to Snehaloy Home for Boys, situated at AK Dev Road, Dhirenpara, Guwahati 781025. And the receipt be submitted before this registry by 15th of July, along with filing a fresh memo parties.
Lordship, thereafter, can it be observed that it may be listed for hearing this 2015 matter?
Can the 15th made 1 or 2 days ago, because that is the reopening day, so it may be.
I have given you therefore this entire week. You are going on out, your applicants are not. Okay, make it 19th. 19th I can't fix it. Payment by 19th of July.
34.
First time,
First out.
issue notice steps. Registered as well as usual. 6.
Public.
मैं तो लिखी दिखो नहीं your application for so and so.
My please, so Lord.
First time.
Sister go to first time.
Okay.
But
May I please your lordship, being agreed by the first appellate court judgment, the appellate had preferred the RSA. And they had filed one IA for staying the execution of the decree. Accordingly, this honorable court had stayed the execution of the decree. And the matter was fixed for hearing in due course.
So you file this?
Yes, the matter is of 2016, and due to execution of the decree, the respondent deprived the enjoying the fruits of the decree, for which I have filed one IA.
So when is the good day you want that the appeal should be heard?
After Bihu, my lord. After Bihu 25
25 or 80, if 25, my lord.
25 of July,
Yes. After
want to
being,
do it.
as per honorable court's convenient timing,
25 of July.
highly obliged.
Is an application for early hearing of the regular second appeal, accompanying regular second appeal, which is of the year 2016. The counsel appearing on behalf of the respondent, who is the applicant, submits that there is a concurring finding of fact
No, madam.
that the applicant have been deprived of the fruits of the decree in view of the execution having been stayed by this court, and therefore is that the matter may be heard at an early date. Taking into account that the appeal is of the year 2016 and almost 8 years have passed by, this court fixes the instant appeal for hearing on 25th of 25th too early. Let's have it on 8th of August. 8th of August, whose the appellants, the parties in the parties herein shall be at liberty to mention the matter for upgrading on that date.
If you obliged.
If so, advised. I disposed.
Thirty-seven.
Within time,
Yes,
it is who died?
appellant died.
An application filed for under Order 22, Rule 3 of the Code of Civil Procedure for substituting the legal representatives of the appellant who expired on
6/3/2024.
6/3/2024, taking into account that the application is within time and the right to sue duly subsist upon the legal representatives of the respondent appellant, this court substitutes the applicants herein against the name of the sole appellant. The applicants herein shall be arrayed as respondent appellant numbers 1.1, 1.2, 1.3, 1.4, 1.5, 1.6, and 1.7. The registry shall make necessary correction. The counsel for the applicant shall file a fresh memo of parties before the registry by 28th of June 2024. Basis thereof, the registry shall make necessary correction in the title as well as also did the same in the CIS. I stands disposed.
Lordship, another cross objection in that application I have filed in substitute.
Huh?
Cross objection is also there.
You have also filed.
Yes, your lordship.
Why do you need to bring it? He has already brought it.
Yes. Let me,
IA number 1483/2024. The A.R. Som, the learned counsel appearing on behalf of the respondents submits that the instant application has been filed to substitute the legal representatives of the sole appellant who expired on 6/3/2024. So taking into account that in IA number so and so, this court have duly allowed the substitution, no further orders are required, in as much as the further orders are required.
oblige, your lordship.
Okay. In cross objection, do you put the names? You don't put names out there. Okay. এটা কাম কৰো এইখন লিখিব has filed this application and so take account the order which passed in I number. This application is also allowed whereby the opposite party to the accompanying cross objection number 2019 shall be substituted by the names by the applicants, by the appellants. The newly substituted appellants. And they would be arrayed as opposite party number 1.1, 1.2, 1.5, and 1.6 and 1.7. Mr. A.R. Som, the counsel appearing on behalf of the cross objectionist, on behalf of the cross objector in cross objection number 1/2019 shall file a fresh memo of parties and the registry shall on the basis of the instant order within 28 and the registry shall on the basis of the instant as the memo of parties and shall update the same in this 1884 congress.
38.
First time. Notice. And first time. Notice. Yes. You are appearing here?
Yes, my lord, I am appearing on behalf of the respondent, sole respondent.
Yes, file caveat or color knowledge.
My lord, I have been given instruction by the respondent to appear before the court today.
You appear today. I will condone the delay. It's only 46 days. I will
Yes.
condone the delay.
My lord, I have an objection. The
Wherever
case-
your objection has no meaning. With 46 days, the court is going to do it. I'm not saying, but if I condone it tomorrow, somebody may say you are not there.
Sorry, my lord.
Somebody will say that we have never appointed him. When the court has not yet issued notice in this case, unless you are in caveat, how can this court, we can take judicial notice of your appearance?
My lord, I have been given instruction.
Instruction one, did you file the wakalatnama?
Yes, my lord. In the morning, I have filed with the registry, with the filing.
The copy?
My lord, I haven't.
We do it, right? 39, we have it Wednesday. We condone the delay. Okay. Was the Mr. So-and-so appearing on behalf of the respondent? Respondent, na?
Yes, ma'am.
How many respondents are there?
Sole respondent.
Respondent submits that he has been duly authorized to appear and has also filed his power. List the matter again on 27/6/2020.
My lord, delay is not condoned. It will be taken up on the next. Okay, much obliged, my lord.
The registry shall duly as regards the filing of the wakalatnama. Shall update the status as regards the filing of the wakalatnama and sub. Where is she? Yes. See, now I am giving you. We still 445 na? Chalo. Ekon aaye. Ite diyo. RSA ekon diyo. Let's dispose of the RSA. Agi. Who is the appellant?
They are the appellant.
Yeah. Let's dispose of the RSA. We have too much of time. Why should we go into these petty matters?
My lord, they have filed this application under order 39, my lord.
Who?
The
Forget
respondent.
about them. You argue. Let us see what is your case, RSA. There is already a let the matter be listed for hearing. Where?
My lord,
What is the order?
Just today I have filed my Okalat now, my lord. Today
Let us,
morning.
both of us be prepared.
In the, they have started construction, lordship, they have.
Okay, okay, let us see whether, you see,
lord.
your appeal, if it is allowed, allowed. Whether while reversing the finding of the trial court, the first had applied its discretion in decreeing the suit for specific performance on the basis of the evidence on record. That's all.
My lord, there is a-
Madam, you come this way, you go this way. Yes. Simple case. Second appeal is 25 minutes. We have 1 hour.
the suit was for my lord, specific performance of contract, my lord. I am the defendant, my lord. As alleged, my
Suit
lord,
was
the
dismissed.
suit was dismissed. Initially, it was dismissed. In appeal, it was reversed, my lord.
Why?
Uh,
Why was the suit dismissed?
It was dismissed, my lord, as the agreement, my lord.
Huh.
Is not tenable. As per the agreement, my lord, they must.
Let us see the trial court judgment. Ogendra Chandra Das, Viren Rajbangshi, suit
Lordship,
for
it starts from
specific performance of the contract for sale.
38, page number 38 onwards.
Is when so to sale out of 1 kata iman and so. The agreement is there. And notice is there. Agreement 2006, notice is there 2006, suit filed in the year 2008, within time. Then, what is there?
There's a condition precedent, my lord, to pay
What
the
was?
amount within 35 days, my lord. They failed.
Page?
Within 35 days, the remaining amount must be paid within 35 days from the date of execution of the agreement, my lord.
Ah.
They failed to pay, my lord. Then subsequently, they have made an agreement with the mother of the defendant, my lord. Then they filed that as the mother is also the party to the, my lord,
Mother is not a party into the suit.
mother was made party, my lord.
No. Viren
She was not
Rajbangshi.
made party. She was not made party.
Huh?
She was not made party, my lord.
So that is why.
And therefore, the trial judge, my lord, dismissed their suit, my lord, as they not able to pay the remaining amount, my lord. In the appeal, my lord. it was
Wait. Or defense. You have only denied.
I denied, my lord.
Was a lapse on the. So she, as per the plaintiff, the money was paid to the mother of the.
Mother of the defendant,
Who was the owner of the land?
the defendant, my lord,
Not the mother.
not the mother.
Was there any receipt? Let's see the trial court judgment. The trial court judgment.
38, lordship. Findings in page number 41.
For Iman. Defendant and his mother executed an agreement to sell.
Subsequently, my lord, the issue number 3, my lord, it is needless to discuss the detail of the exhibit 1. Plaintiff had to pay the leftover amount to the defendant within 35 days from the date of agreement, that is 19/10/2006, which is not complied by the plaintiff, who actually executed another agreement with the mother of the defendant on 1/12/2007, exhibit 3.
Go to issue number 4. Where the appellate court judgment?
The court judgment starts from page 60, Lordship.
Let's see the agreement.
Agreement page 20 onwards, Lordship. 20 onwards.
Let's read it. The register agreement.
Register agreement.
Exhibit 1.
Exhibit 1.
Hiren Rajbangshi. So the terms, read it.
এক লাখ নব্বৈ তাত বন্দবস্তি কৰি উপৰোক্ত বৰাবৰৰ ঠাইত খৰিদ বিক্ৰী কৰি দিলো আৰু বাকী নগদ ৮০,০০০ টকা আগধন ললো। প্ৰকাশ থাকে যে আজিৰ পৰা ৩৫ দিনৰ ভিতৰত হেৰি ৰেজিষ্ট্ৰি কৰি বৰাবৰক সমুদায় টকা আদায় দিব লাগিব। ৩৫ দিনৰ ভিতৰত ৰেজিষ্ট্ৰি কৰি বৰাবৰক সমুদায় টকা আদায় দিব লাগিব।
Registry kori. So it is for you to do the registry. That is not the word.
তৃতীয় পক্ষৰ উল্লেখ থাকিল বৰাবৰৰ টকা বেচা কিনা কৰাৰ জমি ৰেজিষ্ট্ৰি কৰাত আমি সন্মতি দিম। সন্মতি দিম। অন্যথা কৰিলে আইনৰ দায়ী জগৰীয়া হম। ইয়াত আমাৰ বা ৱাৰিছৰ কোনো আপত্তি নাথাকিব।
Registry kori. It is you who can do the registry.
And they will file the consent, my lord, because to registry, my lord, to first apply for the permission, my lord. For permission, they have to also apply for affidavit and all.
Did you say anything in your written statement? Nothing.
We have denied, my lord. We have denied, my lord.
No, no. Anything that we asked them, they have not come.
That specifically was not.
No plea.
Only simple denial, my lord. I have seen, my lord, there's only simple denial.
We dismiss the plea. So, injunction not necessary.
My lord, may I pray, my lord, because today morning only the client has engaged me, my lord, on this hand over the brief.
No, no, no.
Which?
I have served notice on file day of filing,
Me, my lord,
Lordship.
me.
Why did they engage you today morning?
Mr. Sharma was engaged earlier, Lordship. I have filed, I have served notice to him also.
And the appellant cannot engage like that. You have filed your wakalatnama?
Today morning, my lord. Today morning I have filed. I also informed my colleague, my lord, about this.
Who was earlier there?
My lord,
He was there, my lord.
I was there, my lord. Considering the complication of this matter, considering the complication of this matter, my lord, I engaged my
You engaged?
pay itself, my lord.
Hello?
My-
So, how does it make any sense? You don't have a case.
I am not engaged, my lord. I take consent from the party, my lord. They file wakalatnama. I am not engaged, my lord.
You know, sometime,
don't-
my lord, because today only, my lord, I appeared. And
That
regarding
is
the-
your look out. Your name has not been shown.
because today
So,
only-
and that too without the I. Double E. It has to be shown, otherwise you don't see. Isn't it?
today morning, my lord, and only because the injunction application, which was, my lord, listed, and I am so going to the injunction application only. That's why, my lord, I am not.
What is the injunction you are asking for?
Lordship, they are constructing the building, Lordship, which
Ah.
in the-
Stop all construction. You don't have a case.
Injunction application without having any schedule, madam.
Not necessary. The schedule will be as per that suit.
I have the latest photograph, Lordship. They have insert pillars also.
Will be as per the suit. Did the suit have a schedule?
Has the schedule, lordship.
Did
but
the
in
plate have a schedule?
Yes, but in the injunction application, they did not file any schedule, my lord.
Did the plaintiff have a schedule?
Yes, yes.
Yes.
So it's okay. It will be this land. This is an application. Order 39, rule 1 and 2. Read with section 151 of the Code of Civil Procedure 1908, filed by the appellant. Taking an injunction that the opposite parties herein, who are the appellants. No, you are the
I'm the respondent.
and this is an application under Order 39, Rule 1 and 2, filed by the respondent herein, who is the plaintiff in the suit.
Lordship.
Lordship, I may be allowed, my lord, one sentence, my lord. I, my lord, engaged today, my lord, even cannot try to convince, my lord. One date, my lord, kindly, my lord.
For what?
It may not be dismissed, my lord.
I'm not dismissing it. I'm passing an injunction not to construct anything. And if anything happens, we'll take it up. An application under Order 39 filed by the applicant, who is the respondent in the accompanying appeal, and also the plaintiff suit, seeking an injunction that the respondents, opposite parties herein, who are the appellants, should not be permitted to construct any structures over the land have been specifically described in the end of title suit number
Title suit number, Lordship.
124/2008. This court have duly taken note of the dispute involved. In fact, the matter was heard. Mr. Iladitya with Dabuli submitted. He needs some more time to prepare. This court have duly found that there is a strong prima facie case in favor of the applicants herein, who are the who is the plaintiff in the suit. The decree which has been passed by the learned first appellate court is also in favor of the plaintiff. Any construction or creation of any third-party rights over the suit land described in the plaint of the suit would be seriously prejudicial to the interest of the applicant. Under such circumstances, this court directs that the appellants herein, who are the opposite parties in the instant application, not to carry out any form of construction over the suit land described in the plaint of title suit number 124/2008 till the disposal of the connected second appeal, being RSA number 304/2018. I stand disposed. Appeal to due. Taking into account that the instant appeal has been heard at length and a further opportunity is being sought for, list the matter again on 16th of July 2024, on which date at the top of the list showing it as part heard. Which state this court shall dispose of the instant appeal, shall take So you survived for 14 days.
My respectful submission is that, my lord, the section 16C, my lord, regarding, my lord, specific relief act, my lord, section 16C, my lord, that part has not been considered, my lord.
16C has been duly considered as regards readiness and willingness. Everything has been done. First appellate court judgment is absolutely takes care of anything. In fact, the trial court judgment is also against you. The last paragraph, the penultimate paragraph, says that whatever may be, you were to pay within 35 days, they have not. That's the ground. But the question is, that word, he missed out. Registry kori 25 দিনের ভিতর। This is the word. Otherwise, you had a case.
Let me see.
That word is not there.
Yes, my lord, let me check the evidence, my lord. Otherwise, my lord, within 35 days, whether it is a valid agreement or not, because it is not possible within 35 days.
Whether it is there or not, therefore, and more particularly, one has also to take note of many judgments of the Supreme Court which say the time mentioned in an agreement for sale is not here. And more particularly, the suit was also filed with not much late. It was filed, the agreement was of 2006, and in 2007 only the suit was filed, 2007-8. So it was.
Time is the essence of this agreement.
Time is the essence. No, time is not the essence. Time is not the essence, is the judgments. However, recently, the Supreme Court has come up with one aspect to the matter wherein it says that if there is some, maybe they have got 3 years to file a suit, there's no problem with that. But the court may use a discretion not to grant it. In the circumstances, it is seen that there is also a fault.
Let me check the evidence part, my lord. Otherwise, my lord, I am not this court.
Mr. Shiladitya, the history shall show the name of SW.
Obliged.